Uh,
Good morning,
and
sir.
yeah, I invite everyone for this wonderful session. Before me starting with my presentation, I want to make few disclaimers here. And the disclaimers are, I want this meeting not as a session, but this meeting as a discussion. So the more the participation, the more the discussion happening between participants along with me, that will give some kind of great input because this interplay between IBC and Companies Act is not generally a common topic, and we all have to understand what that 11th schedule and the Section 255 is speaking, which is not a normal activity in any way IP's life. So that is where I want to have more of discussion. And another disclaimer I want to make is there are certain provisions, the scenarios, rather, I would say, those scenarios, even in the present corporate world, they have not yet witnessed. Maybe in future, we may be able to see such kind of scenarios, what that is being envisaged in IBC 11th schedule versus Companies Act. But there are few situations which we have not even witnessed in our practical career life. So with that disclaimer, I want to proceed ahead and try to participate with your discussion as much as possible and try to stop me wherever you want to have some kind of discussion. Is that okay with everyone? I'm sharing the entire screen. Is the screen visible to everyone?
Yes, sir.
Yeah, thank you. Yeah. So this is the interface of IBC with the Companies Act. As I already mentioned, what is that? To this? Ah. So what are the provisions where there is an interface between IBC and Companies Act? Let us see. Mainly, as I told you, it is 255 of IBC, which reads with the 11th schedule. And that 11th schedule, I am proceeding ahead to present before all of you. Rather, as a PPT, I also want to share in between that 11th schedule versus that IBC provisions directly, because we need to understand each and every line item mentioned in the provision in a clear-cut manner. Yeah, if you see, this is the 11th schedule. The first point in section 2, there is a clause 23. They want to insert that clause 23 is company liquidator. Company liquidator means a person appointed by the tribunal as the company liquidator in accordance with the provisions of section 275 for the winding up of a company under this act. So let us see what that 223 says in the Companies Act. This 223. Company liquidator means a person appointed by the tribunal as the company liquidator in accordance with provisions of section 275. So straight away, Companies Act is giving an interconnection to 275 section where the appointment of liquidator will be happening by the tribunal. And when this tribunal will do that kind of appointment, when the tribunal wants it in case of winding up by the tribunal itself directly. So the winding up of tribunal is not covered under IBC, but it's covered under Companies Act. So this scenario, under this scenario, tribunal will appoint the liquidator. And then the company or creditors in case of voluntary winding up. If you see, basically the company or creditors in case of voluntary winding up. Voluntary winding up is already covered under IBC. Then what kind of scenario they are envisaging under Companies Act, we need to understand. As well as the same kind of scenario applies for the company and creditors also. How a company and creditors apply for the voluntary winding up, that we need to understand. And whenever this tribunal is appointing, They are appointing from the panel of professionals maintained by the central government under Section 275, subsection 2. So 275 subsection 2, again it gives connection to the IBC code itself. So who are all the insolvency professionals? Those insolvency professionals are only getting appointed for winding up by the tribunal in both the scenarios. That is, tribunal in case of winding up by the tribunal, or by the company or creditors in case of voluntary winding up also. Whereas if you see coming to the IBC, there is a section 5 subsection 18. Liquidator means an insolvency professional appointed as liquidator in accordance with the provisions of chapter 3 or chapter 5. So chapter 3 is the liquidation procedure after the CIRP process, and then chapter 5 deals with the voluntary liquidation process.
So,
Now,
sorry to
yeah,
interrupt. One small doubt, sir.
yes,
Uh, whether this voluntary winding up is still continuing, sir? Is it not completely transferred to IBC?
that is the scenario we need to understand. Before me answering that question, let us understand what is the difference between winding up, what is the difference between winding up and liquidation and dissolution. On a normal parlance, let us understand this. This is very crucial and very important also. Liquidation is talking about the liquidation of the assets to repay the liabilities, whatever the company is having. So it is a pure process of realizing the assets and repaying the liabilities is called the liquidation process. Whereas in winding up, that is a part. The liquidation is also part of winding up. Apart from that, we are also trying to wind up all the affairs of the company. In certain scenarios, there may not be certain assets and liabilities also, but there may be other kind of transactions where we want to wind up the affairs of the company in total. So winding up is a process. Liquidation is also a process. But liquidation deals with selling of assets and repaying the liabilities, whereas winding up deals with entire scenario of winding up all the processes, all the transactions, all the dealings with the company. Then what happens at the end? Dissolution will happen both in liquidation as well as in winding up also. But in liquidation, what happens? Liquidation sometimes, if company we have sold out everything and everything is done, then you can make an application for dissolution with the tribunal so that the company will be wound up there, closed. But in certain scenarios, we will also sell the company as a going concern. Then what we will make an application before tribunal under IBC is the closure of liquidation process. So the application for closure of liquidation process is different from application filing for the dissolution of the company. So liquidation is giving a sequence for us, some kind of possibility for us that company will be alive because we can sell it by in the way of going concern, and then we are closing the liquidation processes. So assets and liabilities, everything is done. Now the company has gone to someone else. So that is where we are closing the liquidation process. Otherwise, assets are sold and liabilities are paid and there is nothing in the company. Now you want to close the company also. Then we apply for the dissolution of the company. Whereas in winding up, there is no such concept like we are selling the company as a going concern. We have to wind up everything. The company has to get dissolved. So the dissolution only will happen in winding up. So in such scenario, I will also tell you where all the scenarios this winding up by the tribunal happens so that we can understand whether voluntary winding up by the company or creditors is still available or there is a possibility under Companies Act. Yes, right now the possibility is there and under the Companies Act also, but it is a very rare phenomenon. Normal practice, we do under IBC only, that voluntary liquidation, section 59. Am I clear on that?
Sir, so far I have been under the impression that liquidation is a term used in the IBC. Winding up is a term used in the Companies Act. Once
Yeah,
it is under IBC, it is called as liquidation. The same process, whatever we are selling the assets of the corporate debtor, and even there we are filing application for dissolving the company. Here, there
yes,
also the
absolutely.
companies, all the functions, everything is completely dissolved.
Right.
And
And your
so
understanding is
that is
correct
how
also.
I was understanding. And only the compulsory winding up is still continuing with the Companies Act.
Companies Act.
Voluntary
Yes.
winding up has been transferred to IBC. That is my
Yes.
understanding.
Absolutely. Absolutely correct. See, when you talk about liquidation, liquidation will happen through IBC only. Liquidation is not a process mentioned in Companies Act because that is transferred to IBC. But winding up is there with the Companies Act only. Now, what the difference I want to bring here is in liquidation, dissolution petition versus the petition for closure of the liquidation process. There are two scenarios. So that is possible under IBC. But under Companies Act, it is winding up only. And after winding up, you have to make a petition for dissolution only. So straight away, dissolution will happen. But the voluntary process, again, there is a difference. That voluntary process, generally we see under IBC, but the voluntary process is also possible under Companies Act. That scenarios we will see while we are proceeding ahead. Okay? Yeah. So, since the connection is given under 275 for the purpose, let us see what this 275 says. First, understand, let us subsection 2 itself. The provisional liquidator or the company liquidator, as the case may be, shall be appointed by the tribunal among us the insolvency professionals registered under the Insolvency and Bankruptcy Code. So, this is what even the Companies Act gives the power to the tribunal to pick those liquidators, and those liquidators shall be from the insolvency professionals pool only. There are no other professionals who can act as provisional liquidator or company liquidator. Now let us come to the subsection 1. The subsection 1 speaks for the purpose of winding up of a company by the tribunal at the time of passing of the order of winding up shall appoint an official liquidator or a liquidator from the panel maintained under subsection. So now what it says, either tribunal can appoint an official liquidator or a liquidator. The official liquidator, again, there is no such concept like insolvency professional can be appointed as an official liquidator for the company for wherein it is the winding up by the tribunal. So official liquidator is a government officer who under the judicature of respective state high courts, and he only will be appointed. But there is a possibility of appointing a liquidator where winding up by tribunal is possible. For that liquidator can be from the pool of our insolvency professionals. Again, there is two category: provisional liquidator or company liquidator. In two ways, it is possible. Now, let us understand the scenario how this winding up process under Companies Act can happen. The moment petition is filed for winding up, the order is passed by the tribunal. So, winding up order is passed. So, that means the company is about to go into the process of winding up. So, under that winding up process, it is possible that for the tribunal, a company liquidator will be appointed. Company liquidator again is an insolvency professional. Sometimes what happens, you have made a petition, but the winding up order is not yet passed. Still, that process is going on. But the tribunal, if it deems or assumes that there is a necessity to have one person from the tribunal side, then in such scenario, the provisional liquidator will come into the place. And he is also should be from the panel of insolvency professionals only.
So whether the provisional liquidator and the administrator are one and the same or two different
No,
persons? Sir?
no, two different
Administrator is
persons.
completely different.
Yes, yes.
Okay.
Provisional
Okay.
liquidator role will, our powers and duties and responsibilities will more or less resemble the duties of the company liquidator. But whereas the administrator's powers, etc., will not resemble the liquidator's role. So both are different.
Can we understand like is it it's like IRP and RP equal to
You,
IRP and RP in IBC for
yeah,
our easy understanding?
yes, you can draw parallels, but there is a small difference also. The IRB is again directly appointed by the tribunal. RP is also appointed by the tribunal. Here also provisional liquidator and official liquidator are appointed by the tribunal under Companies Act. But the problem is here the CIRP process has already commenced. The first 30 days is called IRP and the right to change is given to the COC members. But whereas here it is not like that. The The tribunal feels that, there is a necessity till the time I pass the winding up order to officially the winding up process to commence. There is a concept of provisional liquidator, but after that, he will become company liquidator, or any other person can become as a company liquidator. You can draw parallels, but with this slight line of difference, we have to keep it in mind. Okay,
Thank you, sir.
most welcome. And another thing, the powers, etc., of the company liquidator is already prescribed under Section 290 of the Companies Act, whereas the powers, what all the powers this provisional liquidator has to exercise, nowhere mentioned in the Companies Act, but tribunal will say that the powers more or less what is mentioned in the 290, either you have to exercise that or it can limit also. So the tribunal may limit or restrict his powers by order appointing him to it or by a subsequent order, but otherwise shall have the same powers as liquidator. That is what mentioned under subsection 3. Yeah. Hope I am clear on this definition part of company liquidator. Yeah. Let us see some kind of other differences. There is a section 34 of IBC, chapter 3 deals with the appointment of liquidator. As you all know, IBC, the adjudicating authority, will appoint the liquidator when the liquidation of corporate debtor under section 33 or the resolution professional appointed under for CIRP, he can also become the liquidator and subject to taking the written consent. When this scenario arises, in IBC, when there is a resolution plan has not come, or resolution plan has come but not approved, or resolution plan came approved by COC but not approved by the adjudicating authority, or the COC itself directly wants that this company has to be undergone the liquidation process under IBC. So in all those scenarios, this adjudicating authority will pass an order. That is how the liquidator under IBC will come into existence. Now let us see chapter 5, that is the voluntary liquidation. How the voluntary liquidator will come into the picture within 4 weeks of declaration is because the directors of the company has to make a detailed analysis into the affairs of the company, and then they have to make a declaration of solvency saying that yes, we are healthy and we are in a position to meet all the obligations and all the liabilities. With that declaration, then based on that declaration, the members of the company will pass a special resolution in general meeting requiring that the company to be liquidated voluntarily. And then they will appoint the insolvency professional, and voluntary liquidation tribunal will not appoint. And this resolution of the members of the company in a general meeting requiring the company to be liquidated voluntarily as a result of expiry of the period of its duration in articles. So when this kind of scenario can arise, one thing is first the company should be healthy. It should be in, having a positive declaration of solvency so that it can meet all its liabilities, one thing. And then the second thing, the articles itself says the period. To let us say the company has been incorporated with certain requirement of having certain period. That's it. After that period, there is no necessity of this company as per the articles of that particular company. Then in that scenario, it is possible. Or maybe sometimes how it happens, the articles will specify some kind of event. If this event happens, then after that event, happening of that event, there is no necessity of this company. So triggering the point of that event can also give a chance for the company to go for a voluntary liquidation under IBC. So these two scenarios has to be followed mandatorily. And under voluntary liquidation under IBC, there is another scenario also. Suppose the company is having the debts to any person or creditors, then we have to take two-thirds of the approval from the creditors who are holding two-third value of the debt, and they also need to approve the resolution passed by the shareholders. Then only the voluntary liquidation process will get commenced. But whereas in winding up, it is not that winding up under Companies Act, that is not the scenario. That also we will see. Okay. Now, under companies, there is another interplay between Companies Act and IBC with respect to the custody of assets. There is a slight difference. 283 of the Companies Act specifies the custody of assets that has to be mentioned under subsection 2 as deemed to be in the custody of the tribunal. So, notwithstanding anything contained in subsection 1, all the property and effects of the company shall be deemed to be in the custody of the tribunal from the date of the order of the winding up of the company. So in a general way, they have mentioned that it is deemed to be under the custody of tribunal. So then what? Because notwithstanding anything, the word used in subsection 2. So what is that notwithstanding? What is that mentioned under subsection 1? We will see. So when a winding up order has been made, or where a provisional liquidator has been appointed, the company liquidator or the provisional liquidator, as the case may be, shall, on the order of the tribunal, forthwith take into his custody or its custody or control all the property, effects, and actionable claims to which the company is or appears to be entitled to, and take such steps and measures as may be necessary to protect and preserve the properties of the company. That means what? The so-called provisional liquidator or the company liquidator, whomever may be appointed by the tribunal for undergoing the winding up process under Companies Act, he can take into his custody or control of all the property, effects, and actionable claims. But that, though it is under the control of the particular provisional liquidator or company liquidator, it is deemed to be under the custody of the tribunal only. Now let us see what is that mentioned under 35 and 36 of IBC. 35 1B, it says, take control, to take into his custody or control all the assets, property, effects, and actionable claims of the corporate debtor. That is there. But there is no concept like deeming concept of custody under the tribunal as mentioned under Companies Act. So IBC versus Companies Act, this is the slight difference. It is not to be treated as deemed under the custody of the tribunal, whereas the whole custody and everything lies with the liquidator only under IBC. Whereas in the under Companies Act, though it is under his control, but still it is deemed to be under the control of the tribunal. That is another difference between IBC and Companies Act. So under IBC, the moment we say all the assets are under the control of liquidator, then what is it called? So that is mentioned under 36 subsection 2. The liquidator shall hold the liquidation estate as a fiduciary for the benefit of all the creditors. So he himself is holding that liquidation estate and the fiduciary capacity, like as a trustee. So for the benefit of all the creditors, he is holding that. Then what is that liquidation estate? Let us see. That is mentioned under 36 subsection 1. So for the purposes of liquidation, the liquidator shall form an estate of the assets mentioned in subsection 3, which will be called the liquidation estate in relation to the corporate debtor. So there is a detailed elaboration of liquidation estate saying that there are certain inclusions and there are certain exclusions in under IBC. But that kind of detailed mechanism was not there under Companies Act. So generally, all the assets, all the actionable claims, all the properties, in a vague manner, they have mentioned under Companies Act. But whereas under IBC, they have detailed it in a more detailed manner. So let us see what all those things covered under here. First, let us see inclusions in the liquidation estate. Subject to subsection 4. So there is a linkage for subsection 3 connecting to subsection 4 because subsection 4 is the exclusion. So what all the exclusions are there apart from mentioned, whatever is mentioned under subsection 4, remaining all are included because the definition itself, the liquidation estate shall comprise all liquidation estate assets which shall include the following. So this is an inclusive definition. We need to understand the inclusivity means whatever is not specifically excluded, everything will come and fall under the liquidation estate under IBC. Whereas under Companies Act, that need not be the scenario. So let us see any assets over which the corporate debtor has ownership rights, very commonly understandable, including all rights and interests therein, as evidenced in the balance sheet of the corporate debtor, or an information utility, or records in the registry, or any depository recording securities of the corporate debtor, or by any other means as may be specified by the board, including shares held in any subsidiary of the corporate debtor. That is covered. Assets that may or may not be in a position of the corporate debtor. Sometimes certain assets need not be in the position of the corporate debtor. So some encumbered assets will be there, but not limited to encumbered assets. So that is also covered here. Tangible assets. It can be movable or immovable. Intangible assets are also included, but not limited to the intellectual property, securities, including shares held in subsidiaries of the corporate and financial instruments, insurance policies, contractual rights, etc. Then assets subject to determination of ownership by the court or authority. This is also included in the liquidation estate. Any assets or their value recovered through proceedings for avoidance of transactions in accordance with this chapter. And then any asset of the CD in respect of secured creditor has relinquished the security interest, because the secured creditor has already relinquished the security interest. That asset will fall under the pool of liquidation estate. And any other property belonging to or vested in the CD at the insolvency commencement date, and all proceeds of liquidation as and when they are released. These are all the assets which are included in the liquidation estate. Now let us see what are the exclusions which are specified under 4. So the exclusions are assets owned by third party. If at all it is owned by third party, which are in the possession of the CD, including like assets held in trust, bailment contracts, sums due to any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund, other contractual arrangements which do not stipulate transfer of title but only use of the assets, and such other assets as may be notified by the central government in consultation with any financial sector regulator. And also assets in security, collateral held by financial service providers and are subject to netting and set off in multilateral trading. Sometimes this netting and setting off will happen. So those assets which are falling part of under netting and set off, those are also not covered under this. And personal assets of any shareholder or partner of the CD, as the case may be, and assets of any Indian or foreign subsidiary of the CD. So this D point you please understand. Assets of Indian or foreign subsidiary, because though that subsidiary, whether it is Indian or foreign, it is a body corporate separate from the holding company. It can own and hold the assets on its own. That's why the assets are not covered and is forming part of the exclusion. Whereas my investment as a holding company in the Indian and foreign subsidiary, because that is my asset in the form of shares or investment in the subsidiary, that is covered under subsection 3 as an inclusive definition. So in other assets as may be specified by the board. So these are all excluded. Now, when we are thinking about the interplay between Companies Act and IBC, the nomenclature of the committee, respective committees is also different. The Companies Act specifies it as a advisory committee, whereas IBC says it is a stakeholders consultation committee. So let us see what is that difference. 287 of subsection 1 of the Companies Act 2013 deals with this advisory committee. What it says, the tribunal may, while passing an order of winding up of a company, direct that there shall be an advisory committee to advise the company liquidator and to report to the tribunal on such matters as the tribunal may direct. Now, if you see the wordings of this section, the tribunal may, that means there is a discretionary power given to the tribunal. Whether if it wants that there should be an advisory committee, then only it will say. Otherwise, it need not say also in its order. But the moment it says there is a necessity of advisory committee, then that advisory committee shall be constituted, and what is the role of that advisory committee? To advise the company liquidator and to report to the tribunal on such matters as the tribunal may direct. Because tribunal itself is saying there shall be an advisory committee. It has to report certain things, how it has been dealing with the winding up process in consonance with the company liquidator. That has to be reported to the tribunal by the advisory committee. And subsection 2 also we will see. The advisory committee appointed by the tribunal shall consist of not more than 12 members, being creditors and contributories of the company or such other persons in such proportion as the tribunal may, keeping in view the circumstances of the company under liquidation direct. So the total maximum number of under the advisory committee is restricted to 12 members. These 12 members also is having the composition of creditors and contributories or such other persons as the tribunal may direct. Now let us see how this committee will be looking like in under IBC. So regulation 31A of the liquidation regulations, it speaks about the consultation committee. So the liquidator shall constitute a consultation committee comprising of all creditors of the CD within 60 days from the liquidation commencement date based on the list of stakeholders prepared under regulation 31. Again, here also it is to advise him. So IBC, earlier there is some kind of composition differently mentioned, but after this amendment, it mentioned that it's comprising of all creditors. So all creditors are falling under the category of this stakeholders consultation committee, and the time duration is within 60 days. Whereas under Companies Act, the duration is not there. And the number of members is limited to 12. Under IBC, it is not like that. It is like all creditors. And here it is to advise the liquidator under IBC. Here also, Companies Act, it is to advise the company liquidator and also to report to the tribunal on such matters. That is the slightest difference where we can see from the Companies Act versus IBC, advisory committee versus stakeholders committee. There is another difference also. Tribunal may direct, as per the previous section, so on such matters as the tribunal may direct. But whereas in IBC, they have clearly mentioned what all the items they need to advise. Very clear, detailed manner they have specified under 31A, Regulation 31A, Sub-Regulation 1. So remuneration of the professionals appointed. Yes, if at all you are appointing any professionals, what kind of remuneration can be paid to them? That can be dealt by or advised by the stakeholders committee. Or if at all any sale under Regulation 32 is to be decided, in what manner it has to be done, what are the qualifications for the pre-bidding, what is the reserve price, what marketing strategies and the auction processes has to be adopted, all those things, the stakeholders committee can advise the liquidator. Not only that, the fees of the liquidator, valuation under sub-regulation 2 of 35, that also can be advised by the stakeholders committee. Next, the manner in which proceedings in respect of the preferential transactions, PUFE transactions, how it has to be dealt with, that also can be advised by the stakeholders committee under IBC. Okay, and review of the marketing strategy in case of the failure of sale. Suppose you have issued the sale notice and it is not fulfilled or it is failed. Then how we are going to review the strategy, how we are going to make it as a possible bidding in a fruitful manner. All those strategies has to be can be advised by the stakeholders committee. And then continuation or institution of any suits or legal proceedings by or against the CD, that also can be advised. And extension of payment of balance sale consideration as provided, etc. in auction, as provided in the auction notice, that also can be advised by the stakeholders committee. So that is the difference with respect to the section what I have seen discussed. Yeah. Any doubts on this or anything, any observations from the participants so that I can go to the next amendment what they have mentioned in the 11th schedule. Yeah, seems that we can proceed ahead. Let us see the second one. There is a amendment suggested by IBC for Companies Act under Section 8 also. Section 8 of the Companies Act generally deals with the companies for non-profit purposes, that is charitable purposes. So there the words Rehabilitation and Insolvency Fund formed under Section 269 is replaced with the words Insolvency and Bankruptcy Fund formed under Section 224 of the IBC. Let us see what is that. Since the amendment itself is under Section 8, subsection 9, let us see what is that subsection. If on the winding up or dissolution of a company registered under this section, there remains after the satisfaction of its debts and liabilities any asset. They may be transferred to another company registered under this section and having similar objects, subject to such conditions as the tribunal may impose, or may be sold and the proceeds thereof credited to Insolvency Bankruptcy Fund under Section 224 of the IBC. The first thing, it is winding up or dissolution of the company registered under this section. That means Section 8 company can be wound up or Section 8 company can be dissolved. That is possible under the Companies Act as well as under the IBC also. But what is mentioned here, upon satisfaction of the debts, if there is something still left over or any asset is there for you, generally how it happens in the liquidation or in voluntary liquidation for a normal company, we distribute among the promoters or the shareholders, or maybe the partners in if it is LLP. But here, you are not supposed to transfer or distribute among the promoters of that Section 8 company, because the objective of the Section 8 company is to do the charitable activity, not take advantage of that proceeds by the promoters or maybe the other stakeholders. But liabilities, whatever the debts are there, that debts can be satisfied even under the Section 8 company. So, in that scenario, if at all I have some amount still remaining with me, what I am supposed to do? I'm supposed to do a transfer to another company with the same objects. That means that other company should also be a Section 8 company, or maybe having some kind of similar objects. For that company only, I can transfer the fund. If that is not possible, then conditions can be prescribed by the tribunal, or maybe whatever conditions that has to be satisfied. Otherwise, the remaining proceeds has to be credited to the IBC fund maintained under Section 224 of the IBC. When we see a fund mentioned under IBC under Section 24, there is again a little bit of difference with the fund under 224 versus the fund under mentioned under liquidation process, fund mentioned under voluntary liquidation process. That also we will see. We need to understand this very clearly. So since the initial words used in the section winding up or dissolution, does it mean that Section 8 company cannot be liquidated as per IBC? No, it can be done. Then let us see what is the difference between liquidation and voluntary liquidation mechanism for Section 8 companies. Because the amendment itself was proposed by the IBC for Companies Act with respect to Section 8 companies. So since, as I mentioned, word dissolution is there, it is possible. However, the proceeds shall not be distributed among the members of the company. It has to be transferred as detailed just now mentioned. Now let us see what is this 224 of IBC. Because the remaining proceeds has to be transferred to 224 for Section 8 company. Unlike if you are winding up, or sorry, if you are liquidating a normal company, that proceeds need not be transferred to Section 24 company, but a corporate liquidation account we have to transfer. So let us see this. 224 of IBC says, there shall be formed a fund to be called the Insolvency and Bankruptcy Fund. So what all they can get credited to this fund? If at all central government is giving some kind of grant, those grants can be credited to this fund. If at all some people, they want to deposit as a contribution, just like how we contribute to say Section 8 company, some kind of charity. If something has to be deposited, yes, that is possible for 224 fund. And the amount received in the fund from any other source. Let us say from any other source, if some amount is coming, so that also will be a part of the IBC fund, and any interest or other income received out of the investment made by the from this fund. So you have amount with you, and that amount is invested. Some interest has accrued on that. That interest is also again falling part of this fund itself under Section 224. So this 224 is relevant only for Section 8 companies. Now let us see for a normal company how we will be dealing with it. That is mentioned under Regulation 46 of Liquidation Regulations, and the same kind of nomenclature or wordings is there under Regulation 39 of the Voluntary Liquidation Regulations of under IBC. So there it says, the board shall maintain and operate an account to be called the corporate liquidation account with a scheduled bank. So the power of maintaining this corporate liquidation account is with the board. Board means IBI. And all the proceeds of under liquidation or under voluntary liquidation has to be transferred to this corporate liquidation account, unlike Section 8 company proceeds, which can be transferred to Section 224 IBC fund. Please have this clarity in mind. So what did this sub-regulation 2 says? A liquidator shall deposit the amount of what all can be credited here: unclaimed dividends, if any, undistributed proceeds, if any, in a liquidation process. In voluntary liquidation, just word is voluntary liquidation process, along with any income earned thereon till the date of deposit in the corporate liquidation account before he submits an application under sub-regulation 3 of Regulation 55. So while dealing with the liquidation or voluntary liquidation of a normal company, if at all there is any unclaimed dividend, or if at all there is any undistributed proceeds, those amounts shall be transferred by the liquidator to this corporate liquidation account. Whereas in Section 8 scenario, that has to be transferred to Section 224 of IBC, because this Section 8 subsection 9, the amendment itself says, may, tribunal may impose or may be sold and proceeds thereof credited to IBC fund formed under Section 224 of IBC. This is not there under IBC liquidation regulations and voluntary liquidation regulations. Please have this in. Okay. Yeah. Now let us see how to deal with the Section 8 companies liquidation process and voluntary liquidation. The first question, can Section 8 company be proceeded directly under liquidation and voluntary liquidation under IBC? Any inputs or any observations from the members? There are few questions. Is it mandatory to convert the Section 8 company into normal company? Then only we can proceed for liquidation or voluntary liquidation. Or is it possible after conversion? Suppose, let us say it is mandatory, saying that, it has to be converted, then only you can go ahead. Then in such scenario, after conversion, then how to deal with the amounts lying in the books of Section 8 company? And what is the relevance of this 46 and 39 of liquidation and voluntary liquidation regulations? Let us see all these questions. Yes, Section 8 company B. Yeah, Srinivas sir, please.
Sir, Section 8 company, as far as my understanding is concerned, it is established for charitable purpose.
Yes.
How it can come into IBC when there is no debt due, or there is no debt and default?
Sir, can we say for a Section 8 company
It
there are no debts and
it can't raise any loans and all those things, no, sir?
true, sir, but
Uh, it is
directly for the business
not for
purposes,
commercial purposes.
correct. But can we
Company
say
is
that,
not for Can it
it
run any
can,
business, sir? A Section 8
no,
company? No.
business in the sense, if you are
Uh,
trying to make profit out of the business, that is not possible.
but
But you can do business to give the beneficial, more benefit to the purposes or the charitable objectives what you are doing. That can be done out of the funds generated from the Section 8 company. But wherein we need to specifically mention in your objects also, then it is possible. Having
okay.
said about this, there is a possibility that Section 8 company can also have some kind of debt obligations. Debt obligations, sir, please don't think
It's
that,
not
there is some
commercial, no,
kind of
sir?
pardon?
It is not commercial loans and all those things.
No. Yeah, that is what I mean to say. We
Yes.
should not think that it is a commercial loan taken from some kind of financial institution or some
Yes.
financial body. It is not like that. Some kind of
Okay.
statutory obligation is there, which you have
Even
not paid.
among their members itself, they can take, sir. They can claim debt and default.
No, in the form of debt, you cannot take, sir. If it is a
Uh-huh.
Nidhi company, that is
Mhm.
possible under Nidhi company, now, but not under Section 8 company.
Mhm.
Yeah. But, sir,
Suppose the
Section 8
operational
company,
creditors will come, sir, in this main Section 8
hmm,
companies.
hmm,
Persons who
definitely
have
will come.
provided goods and services.
Yes, 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 definitely will come.
Yeah,
That is what I
okay.
am saying. Even
Okay.
statutory obligations will be there. Those
Okay.
obligations are also, it is your obligation to meet. There is a debt
Okay, sir.
outstanding, it will be.
Okay, sir. Mostly operational creditors.
Yes, mostly it will be
Okay,
like that.
sir. Thank you, sir. Thank you.
Thank you, sir. So, in that scenario, now, can we discuss on this, sir? Section 8 company can be proceeded directly under liquidation or voluntary liquidation.
Sir, voluntary liquidation, how can
Yeah. I will give you the
because the
examples also.
75% of creditors,
Member.
they have to give permission and all those things. Voluntary
Suppose,
liquidation.
let us say the company is not having any creditors, sir. There is no
Yes.
creditors in the books of accounts
Mm.
of the Section 8 company. Then
Okay.
creditors approval is not required for me. It is
Mm.
only the shareholders' requirement. and
Okay.
shareholders will be there for Section 8 company. Then what is the hurdle, sir? So by all means, let me give clarity on this. Section 8
Yes.
company can be proceeded under voluntary liquidation also. And there is one case filed for under liquidation also, it is going on. I will just deal with those two cases immediately.
Yes.
Uh,
Thank you, sir.
yeah. So it is the reconstructive surgery India, and the voluntary liquidation. It has the NCLT Hyderabad bench. It is under Hyderabad bench only. The status is dissolved, and voluntary liquidation is possible because of this order. That is what the NCLT has taken a stand. And there is another company, Millennium Education Foundation. They have undergone this CIRP process, but under CIRP they could not get any kind of resolution plan. So the liquidation order was passed. The status is still under liquidation. The finality has not come. Because of these two examples, we are lively seeing in the NCLT. So again, let us come back to the question. So can the Section 8 company be proceeded directly under liquidation and voluntary liquidation? The answer is yes. It is possible. Now, how you will deal? Is it mandatory to convert the Section 8 company into normal company? The answer is not required. You need not convert that Section 8 company into a normal company. And let us come to the third question. How you deal with the amounts lying in the books of Section 8 company? Though IBC prevails over all the existing other laws, which includes the Companies Act also. But still, this amendment itself is emanated from the IBC code, the 11th schedule in under IBC. That itself says in Section 8 of the Companies Act, under subsection 9, it is specifically saying that the amounts shall not be distributed among the promoters. It has to be transferred to some other company with similar objects, which is registered under Section 8, or you can transfer it to 224 fund, IBC fund maintained under that. So in that scenario, if at all you have any assets, before we filing the dissolution petition, IA, for dissolution, we have to deal with that balance funds in that manner specified under subsection 9. Then we will be complying with all the provisions, and this regular section 8 can also be liquidated, or voluntarily liquidation process also can happen. Now let us see this regulation 46 and regulation 39 of the liquidation regulation, both the regulations. How we can bring this relevance to section 8 companies? Because regulation 46 of liquidation regulations or 39 of voluntary liquidation regulation says the balance amounts has to be transferred. That is unclaimed dividend or undistributed proceeds. It has to be transferred to corporate liquidation account. It is not section 224 fund. On one hand, IBC itself says for all companies, it has to be transferred to company liquidation account. And on the other hand, through its 11th schedule for Section 8 company, it is saying 224. So for Section 8 company, we cannot transfer those funds, though Regulation 46 and 39 specifies to corporate liquidation account, that cannot be done for Section 8 company. This we have to please keep it in mind. Because there is a analysis for this also. The regulation 46 and regulation 39, the moment it is transferred to corporate liquidation account, what the liquidator or what these promoters can do, they can make an application for getting that funds back. So they can claim that amount from this corporate liquidation account, which is not the scenario for Section 8 company because they cannot take it. The distribution is not possible for them. That is why that has been transferred to Section 224. Under 224, there is no such concept like making an application to claim that amount what is been credited to the fund. But for regulation 46 and 39, corporate liquidation account, you can claim back by making an application to the liquidator if dissolution order is not passed, or even a dissolution order is passed. Still then, these people can make an application to claim that amount by making an application to the board. That is possible, sir. Am I clear, sir? Or anything you want to discuss on Section 8 companies? If you want to see those orders of those two companies, that also I can show you, sir. The order is passed, step one is status dissolved, and the other one is still going on. Yeah, let us see the third amendment. In Section 66, there is an inclusion of subsection 8 for the words etc. is unable within the meaning of subsection 2 of Section 271 to pay the amount of his debt. So, in these words, the words commits a default within the meaning of Section 6 of IBC. So, instead of unable to pay the amount of his debt or claim, they have removed that and made a mention of commits a default within the meaning of Section 6 of the IBC. So what this Section 66 is, let us see that. So it is basically reduction of share capital. And under what this subsection 8 says, where the name of any creditor entitled to object to the reduction of the share capital under this section is by reason of his ignorance of the proceedings for reduction or of their nature and effect with respect to his debt or claim not entered on the list of creditors, and after such reduction the company commits a default within the meaning of section 6 of IBC in respect of the amount of his debt or claim. So let us understand this situation. The company is trying to make an application for reduction of share capital. While making a application for reduction of share capital with the tribunal, they have to prepare one list of creditors. Because the creditors has to give their no objection, and they may also need to approve this reduction. It should be okay for them. They should not object this. That is the main purpose of Section 66, reduction of share capital. Now let us see, there is one creditor who has missed out. And he could not make an application because he was ignorant of this section, and the proceedings all everything was happened, and his name was not there in the list of creditors. And after that, what happened? Reduction of capital and everything was over, and then after some time there is a default committed by the company under Section 6. That means that one IBC default, whatever is there, that has happened. Now there is a right for the creditor to make an objection, but that person is not there in the list, and he was not included, and he is also ignorant of this process. Then what he can do? There is a issue for him, and he wants to object to the reduction. That is his intention. If there is no objection for him, even though there is no his name is not mentioned in the list of creditors, there is nothing going to happen, because effectively nothing is kind of causing a harm to that particular creditor. But this fellow wants to object to the reduction of share capital because his name is not there. His right was not exercised. He was deprived. So what he can do? So, and basically, we have to understand why these people, the creditors, should be included in the list of creditors, and why the approval of these creditors are required for reduction of capital also. Let us understand this scenario. In reduction of capital, what happens? When you are reducing the capital on the liability side, similarly, your obligation on the asset side, everything is also getting reduced. That means whatever the creditors are supposed to receive out of the assets of the company, there is a reduction for them. So some kind of haircut will be there for all those creditors when you are reducing the capital on one side. That is possible under Companies Act. That means when my right is getting impaired, I'm supposed to give my consent to that, whatever the transaction is happening. That is most important. And when reduction is happening, let us see if the company is wound up, the tribunal may, on the application of any such creditor and proof of his ignorance as aforesaid, if it thinks fit, settle a list of persons so liable to contribute and make and enforce calls and orders on the contributors settled on the list as if they were ordinary contributors in a winding up. Because his name is not mentioned over there, since his right was deprived, what this person can do, this fellow can make an application to the tribunal saying that I am a creditor, but my name was missed out, and he has to prove his ignorance also. Just like that, randomly he has come up before the tribunal and saying that, I am making this application. No, he has to prove his ignorance also. Then the tribunal will look into all aspects, and then it will prepare the list of the people who are supposed to contribute. And then because these people will be contributing, his objection can be heard, or his interest will be taken care by including those people as liable to contribute. That is what happens under section 66 subsection 8. Anything the participants wants to discuss on this?
Sir,
Yeah. Yes, sir.
in IBC, if a reduction of capital is in the plan, there is no need of conducting any meeting by the NCLT, members committee
No.
meeting, or uh,
Yeah. Very good question, sir. Let
sir.
me tell you the beauty of resolution plan versus the normal process for a reduction of share capital. In plan, what is happening? The resolution applicant is coming. And till the time resolution plan approved and the implementation of resolution plan comes into place, this person has nothing to do with that company. He's not even a stakeholder in that company,
Hmm.
right? So his
Even in
interests
not
are not getting affected. And IPC gives that kind of privilege for this person because he is coming up and taking up this company by giving a resolution plan. And the main purpose of resolution plan is what? Reviving the company. Otherwise, the company will totally may go into the liquidation, and then your economic activity of the company is in trouble. That means the nation also wants to have the companies running. That is why they want to give this boosting to the resolution applicants to come up with the resolution plans. But here in reduction of share capital under section 66 of IBC, what is happening? I myself is going. The company or the contributors or the members, they themselves are going and saying that my capital, I don't want to have this much of capital, I want to reduce it so that I am restructuring my financial statements pursuant to this reduction. That means I
no,
am
sir.
already a stakeholder in this. That is where I am supposed to make an application here. But there, since the resolution plan is also getting approved by the tribunal, here also it is tribunal, there also it is tribunal only. But the privilege is given to the resolution applicant straight away since tribunal itself is approving the resolution plan also. Again, you need not to follow the procedure prescribed under section 66, etc.
Sir,
That is the analogy, sir.
sir, in IBC also, resolution applicant is proposing the proposal of reduction of share capital, sir.
Yes,
Not
correct,
any members or creditors is asking.
correct.
Only how public shareholder who is uninformed about this COC proceedings and all those things, how he will forego his share becoming 10 rupees to 1 rupee, sir, like that, 100 rupees to 1 rupee, like that. How any prudent shareholder, prudent person will forego their right? That is
Yes.
my.
Sir, this
Uh,
question you are actually asking the basic existence of the IBC itself. The
uh,
IBC has come up with the thought process of removing the controlling power from the promoters, that is shareholders, and then
okay.
giving it to the creditors. Why they want to
Hmm.
do like that? Since these
Okay.
people, in spite of having all the privileges of having the capital in their fund and
Hmm.
management of affairs are there with the promoters, still the company has gone into some kind of troublesome situation. Now that power and everything was removed from them and it is given to creditors so that creditors can invite an outside person as resolution applicant. So here outside person is coming saying that I want to revive. Some kind of benefit has to be given to them, to that person. Otherwise the company will go for totally liquidation and no economic activity is possible in that company. But the objective is
Sir,
not that, to
sir,
revive the
after,
company. Yeah, tell me, sir.
sir, after approval of the resolution plan,
Hmm.
again old directors are continuing, and the plant itself is they are selling. Is it right, sir?
No, old directors are not continuing. No? In any of the resolution
No,
plan,
the all earlier directors are reappointed by the RA.
no, we will
Uh,
not re 99.99% of the cases, all the earlier directors will be
yes.
removed. The directors of the resolution applicant, whom he is nominating, they will come into the board.
Yes, sir. But here opposite is happening. That's why I'm asking questions, sir. They have even sold out the plant and machinery. They want to sell away the land of the factory where it is situated. After taking over the handing of our of all the plant and equipment and all the assets to the resolution applicant.
Yeah.
Is it
No, sir,
possible,
but
sir? Is it how?
yeah, it is
Uh,
possible. No, see,
it is possible, sir. It is happening. How to obstruct it?
no, why you want to obstruct, sir?
No,
That
no,
new
no, no,
person
no.
is,
Because I have lost some money in. I am also a creditor. I didn't apply my claim there. In the I didn't. I am not aware of the proceedings then. So all these happenings, the subsequent happenings of the resolution approved plan has happened. They have sold the plant and machinery. They have sold land and everything. So can
sir,
I
one
file a
thing,
civil suit, sir?
no, no, sir, not possible.
Okay, that's it.
Let me tell you,
Hmm.
we have to understand one particular basic element, sir. The
Sir.
CRP process under IBC, wherein the resolution applicant, who is totally an outsider, is coming up and taking up this company by submitting the resolution plan. So, what is the benefit for all stakeholders? Let us see. Resolution applicant is coming up with the plan saying that I want to revive this company, and so that some certain benefits has to be given to them. Otherwise, it is not possible for that person to take this kind of burdensome company. That is the first benefit. Clean slate policy, and all with all exceptions and exclusions will be given by the tribunal to the resolution applicant. On the other hand, the creditors and everyone are the remaining stakeholders, apart from shareholders, they also get something by virtue of whatever the plan is being prescribed, saying that if they are beneficial to the company, we will keep them, and some amount will be offered to them. Otherwise, it is not been offered to those people.
Sir, sorry
Since
to
it is
obstruct you, sir.
yeah,
Here, shareholders are not getting anything, even a single pie. Then
yeah,
why should they accept the reduction of their share capital, sir? Why should
because
we
it is
involve them in resolution process for
no in resolution,
the satisfaction of the resolution applicant?
sir. In resolution process, this existing the company, why that company is facing CRP, because of whom it is.
Yeah, understood, sir. Hmm.
Sir, you have done something
But
wrong.
no, no, no. Earlier
Uh-huh.
management itself
Management.
is taking those company as a RA. That's my
Uh,
question, sir.
That
That's
is a different
I.
scenario, sir. That again, you are
Sir,
coming under
they are
MSME
coming in the
sector.
back door and they are purchasing this company at a throwaway price, getting away, do away with all these liabilities.
Sir, sir,
That's
this is a point where we should not talk on the open forum. Backdoor entries and all is happening. Everybody knows.
yes, sir. Yes, sir.
But there is no certain curb in the regulations itself how to stop them.
So,
IBC is not envisaged, coming up with any kind of
no
such kind of
purpose of
restrictions.
envisaging objects of IBC is defeated, no, sir. Then that's the
Yeah, it
matter.
is defeated. In certain cases, it is getting defeated. In certain cases, it is fruitful also.
Uplifted also, sir.
Yeah, yeah, yeah.
So full justice we cannot do. Okay.
We cannot do full justice to everyone, no, sir.
Yes, sir. Yes, sir. Yes. Okay. Thank you,
If it
sir.
is a
Thank
normal company and normal scenario, then we can do justice.
you. Oh, yes, sir. Yes.
Yeah, but
Okay.
IBC it is
Thank you.
not possible.
Yes, sir. Yes, sir. Thank you, sir.
Yeah,
Thank you.
welcome. But this section 66, you please understand from the Companies Act perspective. The
Yes, sir.
shareholders are the creditors who are already a stakeholder in that company. They are coming up with the reduction proposal. So while making that reduction proposal by themselves, and company is not going to some outsider, like
My
you'll be
question
happy how
is,
it's going to RA.
sir, my question
Yeah.
is, why can't Section 66 proceedings will also be applied in IBC and make the process more transparent? I am saying this.
Sir,
Because it
if
is
your
a,
analogy,
yes,
let me tell you, sir, if that
because
analogy
there
has
is
to be
a
taken.
every chance of foul play in this process. That's
That's
my,
what, sir. Let me
that's
tell you. If that analogy has to be taken, like this provision has to be brought in into IBC, then every other provision and every other statute, every other department will say that, this has to be brought in into the IBC. No exemption. This has to be done. Then the IBC itself will collapse. There is no necessity of having an IBC code itself. All right.
okay, sir.
It cannot be done, sir. It
Okay,
won't
sir.
work
Thank
in
you.
that.
Mm.
Yeah. Shall I proceed to the Fourth Amendment? Yes, in section 77, in subsection 3, after the words liquidator, they appointed under this act or the IBC as the case may be is inserted. So what is this section 77? We will see. Yeah. Duty to register the charges is the section 77. It is talks about the charges and its registration with ROC, etc. So what this subsection 3 says, notwithstanding anything contained in any other law for the time being in force, no charge created by a company shall be taken into account by the liquidator appointed under this act or the insolvency and bankruptcy code as the case may be, or any other creditor unless it is duly registered under subsection 1 and a certificate of registration of such charge is given by the registrar under subsection 2. Basically, subsection 3 speaks about this what is not to be taken into account by the liquidator, whether the liquidator is appointed under Companies Act or liquidator appointed under the IBC code. So what they are not supposed to take, no charge created by company shall be taken into account by these people unless it is registered under subsection 1 and a certificate of registration is issued by the registrar. That means the moment the liquidator is appointed means what? The company has come up to the winding up stage or liquidation process under IBC mechanism. That till the time of you taking the assets into your control and then trying to absolve them or realize them and making a distribution to all the stakeholders as per IBC or as per Companies Act. Till that time, it is a charge lively existing, but if it is not registered, then it is not like to be treated as a valid registration and a valid charge by the liquidator. That is what this subsection 3 says. But there is a subsection 4 also. Nothing in subsection 3 shall prejudice any contract or obligation for the repayment of money secured by a charge. Why these two subsections are contradicting each other? Apparently, it appears that it is contradicting, but it is not contradicting also. Subsection 3 gives the perspective of how a liquidator has to see if it is a charge is registered with the ROC or not registered with the ROC. But charge is there. Registration is not there. Charge is there. That is what subsection 3 speaks. Subsection 4, what it says, even though the charge is not registered, since there is charge, because there is a contract or there is an obligation, nothing will stop it. That means from the company's perspective, there is an obligation on you to repay back. So that is the company's perspective, subsection 4. And subsection 3 is the perspective of the liquidator appointed under uh, Companies Act or under IBC. And also there is another, one more category, any other creditor also, because this any other creditor also can exercise the saying that, the registration of charge has happened or not happened. If it is not registered, then these people will be treated as an unregistered and unsecured charge holders only. And it is, these people cannot take into account that kind of charges. Am I clear on this, sir? Yeah. So let me proceed with another amendment. Section 117 says, in clause here, the word 304, the word in figures, section 59 of the IBC was substituted. Why? Because 304 is omitted directly and the voluntary liquidation process under section 59 has come into the picture. So what this 117.3, 117 of Companies Act specifically says the resolutions and agreements to be filed. Under section 59 of the IBC, what we are doing before commencement of the liquidation process, as we have seen in the earlier slides, there shall be a mandatory special resolution to be passed by the shareholders. The moment it is a special resolution passed by the shareholders, the special resolution has to be filed under Form MGT 14 as specified under Section 117(3)(f). That is the requirement these people are mentioning. So the interplay between Companies Act is, though the resolution and everything, the process is prescribed under IBC, the filing of form has to be done under Companies Act by virtue of this interplay. Yeah. The next amendment is Section 224, subsection 2. So wound up under this act is removed with and mentioned as or under the Insolvency and Bankruptcy Code. So what is this Section 224? We will see. Actions to be taken in pursuance of the inspector's report. So, and 224 of the Companies Act envisages a scenario where there is some kind of investigation happened and there is an inspector who did the investigation and he has submitted a report. So how to deal with such kind of scenarios, that was envisaged under Section 224. So let us see what it is. If any company or other body corporate is liable to be wound up under this act or under the IBC, and it appears to the central government from any such report made under 223 that it is expedient so to do by reason of any such circumstances as are referred to in section 213, the central government may, unless the company or body corporate is already being wound up by the tribunal, cause to be presented to the tribunal by any person authorized by the central government in its behalf. So what does this mean? There is a company, let us say, that company is liable to be wound up. That means because certain actions or certain things are happening in that company, because of those things, it is supposed to be wound up. But the winding up has not yet started. And supposed to be wind up under what? That winding up can be under the Companies Act and also can be under IBC also. Since the transactions are, compelling that this body corporate or this company has to be wound up, then what the central government should do, they have to rely on certain report. That is the report given by the inspector appointed under section 223, based on what transactions, the transactions and circumstances specified under 213. So there are certain transactions specified under 213. If those things are happening, there will be an investigation and there will be an inspector doing that investigation and that fellow will give a report. That report will be done under the 223. So based on that report, if it is appearing or if central government feels that this company has to be wound up, then central government will make an application to the tribunal in the form of a petition. So that petition for the winding up of the company or that body corporate on the grounds that it is just and equitable that it should be wound up, or an application under section 241. In both kind of scenarios, it can be done. The central government either make a petition to wind up, or under 241 it can make a petition, or both the things it can do. This is what it is. Now let us see what is this 223 and 213. 223, as I said, it is the inspector's report. 213 is investigation into the company's affairs. So what are the scenarios? The business of the company is being conducted with an intent to defraud its creditors. Please pay attention more on this. Intent to defraud its creditors, members, or any other person, or otherwise for a fraudulent or unlawful purpose, or in a manner oppressive to any of its members, or that the company was formed for any fraudulent or unlawful purpose. So this intent to defraud its creditors is not there in the voluntary liquidation under IBC. Because in voluntary liquidation, we are not trying to defraud anyone. We are trying to repay all the obligations. So that voluntary liquidation is a different scenario. But here under Companies Act, if there is an intent to defraud its creditors or members or any other scenarios envisaged here, or the company is was formed for any fraudulent or unlawful purpose, then The inspection will happen, inspector report will be there, and based on the report, petition can be done. Then it is not only running this one, persons concerned in the formation of the company. So the people, the main promoters who are involved in the formation of the company, they are managing the affairs in such a way, it is like guilty of fraud, misfeasance, or other misconduct towards the company or towards any of its members is there. Then also this kind of situation will arise. Other thing is, the members of the company have not been given all the information with respect to its affairs, which they might reasonably expect, including information related to the calculation of the commission payable to a managing director or other director or the manager of the company. That means, let us say the company is paying some kind of remuneration or commission to this managing director or director. That information is not being provided to the members, shareholders of the company, because these people are not having information what kind of remuneration is being paid and whether it is in consonance with the provisions of the Companies Act or not. So that scenario also envisages that there should be an investigation and inspector report, and consequently there can be a possibility of filing petition with the tribunal. That is what is covered under 223 and 230. Any doubts or anything on this? Can I proceed further? Yeah. The next amendment they have mentioned as 6A, that is, the amendment is in section 230. In subsection 1 of 230, again is the words liquidator, the appointed under this act or under the insolvency and bankruptcy code is inserted, even under 230 also. And there is another subsection 6, there also after the words liquidator, appointed under this act or under IBC is included. Let us see what is that subsection 1 and what is that subsection 6 of section 230. 230 subsection 1 of the Companies Act. Power to compromise or make arrangements. This is one section which deals with the mergers, amalgamations, or reorganization and reconstruction of the companies. So, where a compromise or arrangement is proposed between a company and its creditors or any class of them, or between a company and its members or any class of them, then the tribunal may, on the application of the company or of any creditor or member of the company, or in case of the company which is being wound up of the liquidator appointed under this act or under the IBC as the case may be, order a meeting of the creditors or class of creditors, etc. will be there. Now let us understand the scenario. Normally under Companies Act, who all can make an application before the tribunal for this mergers, amalgamations and compromise or arrangement? Basically, the company can do on its own, or the creditors of that company they can do, or the members of that company they can do. This is the normal parallels under Companies Act. Now, let us see how a liquidator can do. So, in case of the company is already winding up, that winding up process is going on, then the liquidator who was already appointed, either under the Companies Act or under the IBC, that person also can make an application. That is where we are seeing this 230 mergers and etc. as part of our IBC process. And when the moment the liquidator is appointed, pursuant to the liquidation order, that person in the initial 90 days, he will exercise or explore the options of possibility of doing a merger or amalgamation of that company for which he was appointed as a liquidator. Because of this allowing provision, that is possible under IBC. Hope I am clear on this. Yeah. So what is this subsection 6 of that 230 we will see. So where at a meeting held in persons of subsection 1, majority of persons representing 3/4 in value of the creditors or class of creditors or members of class, etc. They were voting in person, proxy, postal ballot, etc. as sanctioned by the tribunal by the order. The same shall be binding on the company, all the creditors or class of creditors, and also on the liquidator who was appointed under this act, or that means Companies Act or the IBC. So people have come up with a scheme, that scheme of merger or amalgamation or compromise or arrangement. That entire process and everything is done. So for companies where the winding up process is going on and the liquidator is already appointed, if this scheme is approved, by the tribunal. That is also binding on the liquidator because he is overseeing the aspects of winding up process either under the Companies Act or under the Insolvency and Bankruptcy Code. He is also liable to follow, and the scheme, whatever been approved by the tribunal, is applicable and mandatory to be implemented by this person. That is what this subsection 6 under 230 says. Any doubts on this?
Sir, same process RP is also doing in the resolution.
Yeah. That is part of
There he is not taking NCLT permission or any meeting and all of members or creators,
yeah.
except
So
COC. He is not
correct.
calling all the stakeholders.
Yes.
Only he is
Not all
taking the
also.
approval of only creators.
Yeah.
So could you differentiate?
Yeah.
In
Basically, the
liquidation
difference between
process, it is different, and the resolution process, it is different.
it is different. Yes.
Yes,
That
yes.
is what the main difference we need to understand. In
Sure.
resolution process, the company will be reviving, and there is a plan this with some kind of special benefits, special kind of situation or privileges that person is coming up. To meet those special situations, since the plan itself is getting approved by the tribunal, everything is waived off under resolution process. But whereas in the liquidation, what is happening? We are trying to liquidate the company. Either dissolution may happen or liquidation process will come to an end. That's where all the stakeholders' interests are involved, and there directly the tribunal is not yet approved the dissolution order. See, in liquidation versus CIRP, what is happening? Resolution plan approves, then only the merger and everything as envisaged by the resolution applicant under resolution plan will happen. But in liquidation, order is passed, but dissolution order is not yet passed. But before that itself, the liquidator is trying to explore the opportunity and possibility of 230 in the initial 90 days itself. So that's where the tribunal requirement and following up that process is required under liquidation, whereas that is not required under CRP process. That is the only difference, sir.
Thank you, sir.
Most welcome. So I think, do we need to take a break or should I give a break of 10 minutes or not required? Anjali? Yeah. If members require, I can give 5 minutes or 10 minutes break. Otherwise, we can continue.
Sir, break is needed, sir.
Break is needed. Yeah. So right now, time is 12:05. And shall we assemble again 12:15?
Yes, sir. Thank you. Thank you.
Yeah. Yes. Thank you. Shall, dear members, shall we start again?
Yes, sir. Yes, sir.
Yeah,
Yes.
thank you. Yeah, so 2:30, any doubts on this, sir?
1:30. Your session is till 1:30.
No, 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 no. I'm asking about the session actually. So say, just now I
No,
completed
no
section
doubts, sir. No
2:30.
doubts.
Yeah, okay. Anjali, I know 1:30. Yeah. Okay, so the next amendment is section 249. Uh, so in clause E, the following shall be substituted is being wound up under chapter 20 of this act or under Insolvency and Bankruptcy Code 2016. So let us see what is that section 249 subsection 1. It is restriction for making an application under section 248 in certain situations. This is one peculiar kind of scenario. To the extent of my knowledge, I have not witnessed any such kind of application, but members can share their experience if they have come across such kind of scenarios. Let us see what is that 249 subsection 1. Mainly, it is about the application to be made under section 248 for the striking off of the company. So let us see what it is. An application under 248 subsection 2 on behalf of a company shall not be made if at any time in the previous 3 months the company. So the condition is in the previous 3 months what we are supposed to do, and it is on behalf of the company. Can I make an application under 248 or not is the matter what is being dealt under this particular section. So, if at all the company has changed its name or shifted its registered office from one state to another, yes, that covers under Companies Act, and it cannot make an application for strike off within 3 months because it has already made an application for the shifting of registered office and change of its name. The another scenario has made a disposal for value of the property or rights held by it immediately before cessation of trade or otherwise carrying on of business for the purpose of disposal for gain in the normal course of trading or otherwise carrying on of the business. So let us say some property they have disposed it off for some kind of benefit and which is not in the normal ordinary course of business. Within that 3 months, such kind of company also cannot make an application under 248 for striking off its name from the register of members. Let us see another scenario. Has engaged in any other activity except the one which is necessary or expedient for the purpose of making an application under that section, or deciding whether to do so or concluding the affairs of the company or complying with any statutory requirement. So some kind of statutory requirement is there in the to comply that requirement. They have done some activity. Those type of companies also, if it is done within 3 months, they are also not supposed to make an application within 3 months. So beyond 3 months, they can make it. Now, let us, another scenario has made an application to the tribunal for the sanctioning of compromise or arrangement and the matter has not been finally concluded. So they made an application for scheme of amalgamation, etc. And the matter is not yet finalized. Then also in the previous 3 months, they cannot make an application. Now, we'll see the main thing. Is being wound up under the Chapter 20 of this Act, that is Companies Act, or under the Insolvency and Bankruptcy Code. The word used is being wound up. That means the company has already made an application for winding up and it is undergoing the process of winding up either under the Companies Act or under the IBC. Then an application under this 248(2) cannot be made on its behalf in previous 3 months. Now I am unable to see a scenario where the being wound up company, the process is going on, and within previous 3 months, how it can make an application for striking off its name. Practically and logically, how is it possible? Or is there any situation, maybe till now the corporate world has not witnessed such kind of application, making an application by a company which is being wound up under this chapter or IBC? This is one peculiar scenario. I want to bring it to the knowledge of all the participants. Any observation? Okay. So let us see that subsection 2 of the same section, because 249(1) gives a connection or reference, an application under subsection 2 of 248. So what is the 248 subsection 2? We will see. 248 subsection, without prejudice to the provisions of subsection 1, a company may, after extinguishing all its liabilities. So, a company, if at all it wants to make an application with the registrar of companies under 248 to strike off the name of its name from register of members, what it is supposed to meet, what obligation it is supposed to meet. First thing, it has to extinguish all its liabilities. Then it has to pass either a special resolution or obtain the consent of 75% of the members in terms of the paid up share capital. If these two things are fulfilled, then it can make an application in the prescribed manner with the registrar for removing its name from the register of companies and on all or any of the grounds specified under subsection 1. And the registrar shall, on receipt of such application, cause a public notice to be issued. And this is the another procedural aspect. Provided that in case of company regulated under a special act, approval of that regulatory body, like if at all you are an NBFC covered regulated company, then approval of the NBFC is required. If at all you are covered under SEBI related listed company or something like that, then that approval of SEBI is required. That is what the proviso says. Otherwise, normally after meeting extinguishing all its liabilities and a special resolution is passed based on the ground specified under subsection 1, then it can make an application. That is what it says. So what is that grounds under 248(1)? The registrar has reasonable cause to believe that a company has failed to commence its business within 1 year. That means company got incorporated and within 1 year it has not yet commenced its business. And then a company is not carrying on any business or operations for a period of 2 immediately preceding financial years. So for the past two
Uh,
immediately preceding,
Sir,
yeah,
in in this application, the request has to be given to the registrar. It is not
yes,
before NCLT, right, sir?
absolutely correct. Yes,
Okay, then. Thank you, sir.
yeah. So so the scenario is failed to commence its business and company is not carrying on its business or operations for a period of 2 immediately preceding financial years and has not made an application for keeping it as dormant. Then he shall send a notice to the company and all directors of the company of his intention to remove, etc. And there is another scenario: the subscribers to the memorandum, if they have not paid the subscription money, that is another scenario. And then the company is not carrying on any business or operations as revealed after the fiscal verification carried out under subsection 9 of section 4. So in all these scenarios, these are the grounds. So based on these grounds has to be there, and then after meeting that, it has to extinguish all its liabilities and a special resolution is passed. Then it can make an application under 248 subsection 2. Then this 249 subsection 1 deals with a scenario where a liquidator or a company is being wound up under chapter 20 or under IBC. It cannot make an application within 3 months. This is the situation. How it can be, possible, practically it is possible, that we have to see. Maybe in future corporate companies may come up with such kind of scenario where they can make an application for striking off, though they are undergoing the winding up process either under company act or under IBC. That we need to see. Yeah. So 248(3), in the same section, there is a subsection 3. What it says, nothing in subsection 2 shall apply to company registered under section 8. That means this subsection 2, whatever we have mentioning, extinguishing all its liabilities, special passing a special resolution. So nothing in that subsection 2 shall apply to section 8 company. So if it is a section 8 company, uh, does it mean that even without me extinguishing all its my liabilities, can I do that? That is a question we need to understand. And without even passing a special resolution, can I make an application under 248 for a Section 8 company? Or can a company wound up, how a company can be wound up, can make an application under Section 248? These are the scenarios. I have not come across in my experience. If members have come across anything like that, yes, it can be done. But to the extent Section 8 company extinguishing all its liabilities, it has to happen but it need not be in the same form like how we repay all the debts, etc., and then go for strike off. Because Section 8 company says all the assets can be transferred to some other company which is having similar kind of objects. Likewise, what I am envisaging is there is a possibility that liabilities can also be transferred to that other company and then make an application under 248. That could be possible. And passing of special resolution, it is a mandatory requirement, even though it is a Section 8 company, though nothing in subsection 2 applies to Section 8 company, the word used here. Maybe the legislator, it could be a typographical error or something like that. We don't, we may need to see that kind of scenarios in future. Yeah. So this I'm moving to the another amendment. Section 253 to 269 shall be omitted. So what is this 253 to 269? It is the revival and rehabilitation of the sick companies under earlier provisions. There is a SICA Act is there, sick companies, how we deal with that and everything. That is being removed because the sick company, the moment the word sickness is come into the picture, our IBC will come into the play. So totally this has been removed. So another amendment for section 270, it's totally replaced by saying this, winding up by the tribunal. The provisions of part 1 shall apply to the winding up of a company by the tribunal under this act. The surprising thing is IBC covers the creditor related how we deal with that mechanism, that is the CRP process, and consequently the liquidation process. And then if it is like a voluntary done by the company itself, yes, again, the voluntary liquidation process, everything is covered. But the scenario of winding up by the tribunal is given in the Companies Act, but that is emanated as an amendment to the IBC Act itself. So through IBC itself, they are saying that there is a possibility of winding up by the tribunal. Under Companies Act, it can be done. Yes. So the another amendment for IBC proposed is Companies Act as Section 271. Entire Section 271 is replaced with this. What is it? The replaced provision is reads like this. A company may on a petition under Section 270 to be wound up by the tribunal. Suppose the winding up by the tribunal has to happen, then there shall be a petition under Section 272. That is what the Section 271 says. So it shall also have, if a company has by special resolution resolved that the company be wound up by the tribunal. This is where, generally, so far again, I have not seen a scenario where a company by special resolution saying that this company should be wound up by the tribunal under Companies Act. Generally, what happens, Section 59 of the IBC is there, voluntary winding up is there. And there also we will pass the special resolution. Probably a scenario what I am envisaging and I want to place before all the participants is 59 of IBC says there shall not be any default. So the default, that means making the payment of all the debts is the main criteria under IBC. Beyond that, if something is there where I am not covering or satisfying the requirements of Section 59 of IBC, then in those scenarios, still a company can pass a special resolution saying that this can be wound up by the tribunal under 271. That is possible. But so far, no, I have not seen a scenario after Companies Act 2013, this situation. Under 1956, there are so many cases. Even I myself have filed one voluntary winding up of a company under 1956 scenario. But under 2013, I have not seen a scenario right now. And if the company has acted against the interests of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality. Now, please understand this section 271, main subsection 1, or 271 directly. This gives an understanding of how we can close the company. There are 4 scenarios. First, let me explain those scenarios to you, then we will see this 271. First one, the company on its own is making an application to strike off, that is 248 section, which falls under the Companies Act. So 4 scenarios, 2 are covered under Companies Act, 2 are covered under IBC. So 248 striking off. What was the requirement? I have to nil all my liabilities, and then I have to clear all my assets also. So that my balance sheet is nil. And then after satisfying those requirements, extinguishing all liabilities and passing the special resolution, after the criteria specified under the section, like the subscribers not paying the amount, 2 years there are no business activities, or from incorporation the 1 year there is no business activity, and I have not applied for government status. In those scenarios, I can make an application under 248 so that registrar will straight away strike the name of the company so that the company will be removed from the register of members. That is one scenario. The next two scenarios covered under IBC itself, where the first one, it is the creditors oriented liquidation, where an application is made by the creditors, be it financial creditor or operational creditor. Sometimes the company also, section 10, CIRP process. After CIRP, if I didn't get any resolution plan or plan received not approved either by COC or approved by COC but not approved by the tribunal, and COC itself wish that this company should go for winding up, then the liquidation process under section 33, it gets started under IBC. That is another second scenario. The third scenario, that means in the second scenario, my financial health is not good. That is where I defaulted. So the default is there. So I followed the CRP process, and then after exhaust with the CRP process, then I have gone to the liquidation process. Now the third scenario, I am healthy. My financial status is good, and I don't want to continue with the operations of the company. I want to close the company. There I will pass a special resolution, and here also I will extinguish all my liabilities, and whatever is left over, unlike 248 of Companies Act, here there may be a possibility of certain assets or certain fund still left over. That I will distribute among all my promoters or the partners, and then I will make an application under 59(7) of IBC to liquidate. That is a voluntary liquidation process. Suppose these three scenarios. First is directly with the criteria not met, are met, it is 248. My financial health is not good, so CIRP and then liquidation. My financial health is good, I don't want to continue, so voluntary liquidation. If at all I am not covered under any of these situations, then comes the fourth scenario that is dealt under this 271. So what all the scenarios is getting covered now? With this understanding, you please read this section 271. So if the company has by special resolution resolved that the company be wound up by the tribunal, as I explained, apart from voluntary liquidation where I have exhausted all my, repaid back all my liabilities and everything, and then there is no default also, and voluntary liquidation comes. If at all any beyond those situations, still the company wants to undergo the winding up by tribunal, then also by special resolution it can be done. Another scenario, company acted against the interest of sovereignty. So
Sir,
there is a yeah.
um, sir, actually,
uh,
I need some more clarity on this only.
Please.
Um, First of all, if there is a default, then IBC. If there is no
Uh-huh.
default, then only
Companies Act.
Companies Act.
Yes.
Is it like that, or
Yes.
is
You
there
can draw the
all the
parallels.
options are available to all the corporate debtors?
No. If there is a default, so IBC deals only mainly with the obligation of me making the repayment. The repayment obligation, if there is a default there, then CRP after liquidation. If there is no default and I want to pay and close, then voluntary liquidation. Apart from me meeting the obligations or my debt obligations, if there is any other scenario, that covers under 248 and 271. It can be, any other reason apart from my obligation to repay or default.
Like
The
the
financial
company's
default.
objective is completed, so
Yes.
no longer
So,
they want to continue the business. So for those reason only, we can apply under Companies Act.
uh, yes.
Fine, sir. Thank you.
Okay. Yeah, and I hope you have got the difference between 248 and 271 also. 248, I am making my balance sheet nil, and based on those criteria only that four elements: subscribers not paying amount, 2 years not running the business, yeah, after incorporation I have not filed commence the business, and I have not applied for the dormant status. So in those scenarios, so 248 will come. Apart from those four, and apart from there is no default under voluntary liquidation or default under liquidation, all those three scenarios, then whatever is left over, everything will fall under this is 271. Like for example, now the sovereignty and integrity of India is there. So if that company is working against the interests of the nation, then it is possible that you have to wind it up.
Whether this complaint can be submitted by anyone, or is there any
That
requirement for the complainant, sir, in this case?
yes, in this case also the company can do on its own. That is what the clause A we are seeing.
How they will
The
accept it themselves that it has been formed for against the
no,
sovereignty of the country? They will not agree, no, sir.
no.
The
See,
confusion
when
will not
correct,
happen, right, sir. So,
absolutely.
applicant in this case, it is like a complaint only.
No. You are talking about B. No, I am talking about the all scenarios under 271. In
No,
your
no,
case,
sir.
that is
When it is
sovereignty and integrity of
when
India.
these are compulsory, obviously it may not be voluntary, sir.
Yes, absolutely. There the registrar will come. There the company on its own it will not come.
Yes, sir.
If it is sovereignty and integrity of India, the central government will come and make a petition. So
So
here,
in that case, somebody else should alert the central
ah,
government. Otherwise, they will not come to know about it, right, sir?
yes, that we will see in the next slides. It is there. I
Oh,
will
okay, sir.
I will
Thank you.
clarify all the scenarios. So 271 is a very exhaustive one and a very big section, covers wide scenarios. So what are not covered if the company still wants to go on its own? Yes, that is possible under 271 to go winding up and by the tribunal under Companies Act. That is one scenario. The second scenario is company again working against the interests of sovereignty, etc. That is another one. Third one, if on an application made by the registrar or any other person authorized by the central government by notification under this act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner. Still, again, B and C, please understand. B, interest of sovereignty and integrity of India is at stake. C, it is a fraudulent manner, conducting the affairs in a fraudulent manner. Then the company was formed for a fraudulent or unlawful purpose. Other persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and that it is proper that the company would be wound up. Then there is another scenario. If the company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years, that is also can also be one of the reasons for filing this winding up petition. Then if the tribunal is of the opinion that it is just and equitable that the company should be wound up, irrespective of anything, if tribunal feels that, yes, this has to be wound up, then that itself can be a reason. So these are all the reasons covered under 271. Now let us see 272 who can make, so that I can address your query. Subject to the provisions of this section, a petition to the tribunal for winding up of a company shall be presented by the company, because clause A, see now, by the company, if the company has by special registrar. So that is where the company is covered here. Any contributory or contributors, that means that members. So those members also can make an application, all or any of the persons specified in clause A and B together. So these three scenarios is possible for this clause A of 271.
So third
Then,
parties cannot complain against the company.
huh, in
Completely third party cannot raise any complaint against the company under this
no,
provision.
no, it can be done, but how it happens is the petition cannot be filed directly by the third party. He will bring up those issues to the central government. Then central government will authorize one person to file a petition against that company. Or you can make a complaint to the registrar. The registrar then, based on the complaint, he can do on his own. Otherwise, just now we discussed, how these people will come to know.
Yes.
Sometimes they themselves will come to know it is possible. Sometimes they may not be knowing. Then they, based on some complaint given to the registrar or to the central government, these people will file registrar. If it is registrar, directly he can do. If it is central government, that central government will authorize some person to file a petition with the tribunal to wind up that complaint. So
I
in
have one
case,
more query, sir. Sorry to
please,
annoy you
no
by
problem.
question.
Please, please.
Sir,
We need to discuss like this only.
yes, sir. Sir, my question is, assuming I am
Hmm.
appointed as RP in one for a company for a corporate debtor, I
Uh,
find I came to know that this company is constituted for the fraudulent purpose, or it is being run by the promoter fraudulently. Can the
yeah.
IP, can the insolvency professional file a petition or a complaint to the registrar under this provision?
Yes, absolutely, you can do that. That and there your primary responsibility or obligation is you have to you cannot continue with the process of IBC stating the same reason, and that why you are stopping that CRP, the reasons has to be filed through an interlocutory application with the NCLT, and same time simultaneously you have to make an application to the registrar as well, so that the registrar can take an action under section 271 rather than following the CRP process under IBC, because the fraudulent nature is established. The
Okay.
sumoto, you need to have that evidence with you.
Okay.
Otherwise,
So,
again,
do
if you
we?
are,
Is,
uh,
is there any precedent, sir? Is there any case
mm,
where this kind of process took place by the IP?
no, that is what I said in the beginning itself, right? This topic, what I'm going to deal, there are certain scenarios which the corporate world has not witnessed yet. We
Okay,
may see
okay.
it in future.
Because we
It
are
is
not
possible.
aware of all these things.
No, no,
Now,
yes,
that
yes.
is the
Sir,
purpose, whole purpose of understanding this.
Yes, yes. Even that's what I'm telling you. I have not seen these kind of scenarios. We may witness to in future. We don't know. Yeah.
Okay, sir.
Yeah, Srinivas Garu, you have raised
yes,
a
sir.
hand. Yeah.
Sir, can liquidator file application 270 to one with the register and NCLT simultaneously,
Hey,
sir?
sir, if some kind of fraudulent nature is there or
Yes,
something like
sir.
that come, huh?
Section 66 petition is accepted.
Again, Section 66 petition is accepted. Okay.
Accepted. Fraudulent nature is proved, but no action is
66 is
being
different,
taken.
sir. Sir,
Hmm.
66 is reduction of capital.
No, 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 sir. That is under Companies
Acha.
Act, sir.
Under IBC, you
Under
are telling.
IBC,
Okay, okay.
it is fraud.
Hmm.
Okay, sir. So that is accepted. NCLT said prima facie evidences are there to establish this thing, fraudulent nature. But they have appealed to NCLAT. Okay, sir. That may take years. Can I file application under 272(1) and ask them to wind up this matter?
No, sir. The
Uh,
fraud covered under Section 66, that fraudulent transactions
yes,
covered
sir.
under Section 66 of IBC, they have given one right for you to make an application with NCLT. So that
Yes,
is a
sir.
normal this thing. Here, the scenario what we need to see here is
Hmm.
the company was formed. First thing is the company was formed for fraudulent and unlawful purpose, and the persons concerned in the formation or management of its affairs have been guilty of
Yes,
fraud,
sir.
misprision.
That is also proved, sir. Hmm.
Then you can make,
Then,
sir. If this is proved, let's say there is
yes,
a
sir.
possibility of fraud in normal transactions in your day-to-day affairs. There is
Uh,
some fraud happened. It is like normal business-related fraudulent activity. But your purpose itself, the goal, the main objective. Here, the fraudulent word or the object perspective
so
of the
it
word
will
fraud
declare.
is very bigger in sense.
Yes, sir. Yes, sir. I do understand, sir. But the purpose of they are entering into illegal contracts and all hell lot of things they are doing. Can I apply
No,
it
no,
in
no, no.
272(1), sir?
Illegal
No.
contracts and all is a different side.
Yeah, yes, sir.
The formation itself, the basic
Hmm.
tenet of your existence,
Yes, sir. Yes.
that is
Ah,
very dangerous to the nation. So that much of
okay.
gravity should be there
Yeah.
to make an
Then,
application under 271.
That means the terrorism funding and all those things.
Yeah. Otherwise, sir,
Uh,
for normal fraudulent actions, you
mm,
have given power under IBC.
mm. Now
Everything
trade
we
wars
should not
are
see in a bigger sense, no?
mm,
Yeah.
now trade wars are going on, sir. Capital is being shifted to other countries. Can we
Hmm.
apply this thing?
If you can establish that your sovereignty and integrity of India and the interests of the nation are at stake
A stake.
because
Yes,
of
sir.
this company, yes, you
Uh,
can make an application.
okay, sir. Thank you,
Thank you, sir. But as we are discussing, no, I have not come across with the scenarios till now.
sir. Soon we will come across, sir, from
Yeah, we may
Hyderabad
come across,
itself.
sir. We may come
Yes,
across
sir.
because people say that IBC is evolved, the Companies Act is evolved and all. Still, I feel every law it is a continuous journey. The
Yes,
evolution
sir.
is
Yes,
a
sir.
continuous process. We don't know what kind of scenarios will come up in future with the creativity involved the transactions.
Creativity, lot of creativity involved by the promoters, sir. That's
Yes, 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 absolutely, sir.
the-
Yeah, and then next one. Next. Yeah, section 272, subsection 2, it is a petition for winding up. So a contributory shall be entitled to present a petition for winding up of a company, notwithstanding that he may be the holder of fully paid up shares. Now, this also, this particular subsection also, please understand it carefully, sir. Presentation of the petition by the contributory. Contributory means generally what? It is a shareholder. Now, as a shareholder, I have fully paid up shares. That means I don't have an obligation to pay anything. My liability is limited to the extent of my capital, and that capital is fully honored. That is where I am holding the fully paid up shares. In that scenario, still, if contributory feels that there is some kind of situation wherein this earlier we discussed in that 271, then also that contributory can make a petition. Or the company is not having any assets, let us assume, and there is nothing for the contributories or maybe for the creditors to get anything back. Still, then this petition can be filed if we satisfy those conditions, or may have no surplus assets left for distribution among the shareholders after the satisfaction of its liabilities, and shares in respect of which he is a contributory, or some of them were either originally allotted to him or have been held by him and registered in his name for at least 6 months during the 18 months immediately before the commencement of the winding up, or have devolved on him through the death of a former holder. So this contributory can make an application. That is what we have seen in the earlier slides. See, B, any contributory or contributories. So this person will get a right if this person holds fully paid up shares,
Sir,
even
whether
though there is
contributory include creditor also or only promoters?
no only promoters. Contributors will not include creditors because creditors are supposed to get it. They will not give to the company.
Okay, okay. Okay, sir. Thank you.
Yeah. But sometimes this contributory, though this fellow is not a member, not a shareholder, before 6 months, that means he ceased to be a shareholder just within 6 months, then still this person can make an application. Of Let us assume if 6 months are over, that means this person has left the company as a shareholder and 6 months were already over before we making this binding up petition, then this person is not entitled to make a binding up petition. Otherwise, this person is entitled to make a petition as a contributory to the company under section 271. Now, the other scenario, the registrar. The registrar shall be entitled to present a petition under 271, except where the ground specified on clause A. Clause A. Why this clause A is not allowed for the registrar? Because the clause A is by the company on its own. Company by passing a special resolution. So the company itself is wishing to wind up the company under this act, then the registrar will not have any entitlement. Otherwise, in all other scenarios, the registrar will be entitled to make a petition provided that the registrar shall obtain the previous sanction of the central government to present a petition, and provide further that the central government shall not accord its sanction unless the company has been given a reasonable opportunity. That means registrar wants to make a petition to the tribunal for winding up of that company and seeking permission from the central government. What the central government will do, it will give an opportunity of being heard to the company. We want to make a petition for winding up of your company. Do you have any reasons or not? You please let us know. So that is the modus operandi for registrar. Then a petition presented by the company for winding up before the tribunal shall be admitted only if accompanied by a statement of affairs in such form and such manner as may be prescribed, and a copy of the petition shall be filed with the registrar, and registrar shall without prejudice to any other provision submit his view to the tribunal within 60 days of receipt of the petition. This is how the petition and how it is being dealt with by the before the tribunal is looked upon under section 272 subsection 2. Now, there is subsection 3 to subsection 5 also. I have to see just a moment. Yeah. Since we are talking about winding up by the tribunal under Companies Act, let us draw some parallels with section 59 of IBC, voluntary liquidation of the corporate persons. So that the clarity will be there more between IBC versus the Companies Act. Now, section 59, a corporate person who intends to liquidate itself voluntarily and has not committed any default. The crux here is not committing any default is important. Whereas under Companies Act, apart from that, any other reason you can initiate under the Companies Act, as explained over there. May initiate voluntary liquidation proceedings under the provisions of this chapter. And the voluntary liquidation of the corporate person under subsection 1 shall meet such conditions. What are those conditions? Without prejudice to subsection 2, the voluntary proceedings of a corporate person registered as a company shall meet the following conditions. That is, declaration from the majority of the directors of the company verified by an affidavit stating they have made full inquiry into the affairs of the company and they have formed an opinion that either the company has no debt or that it will be able to pay its debts. So the modus operandi under IBC is paying the debts or meeting my obligations towards my debt outstanding. And whether there is a default or there is no default, that is my underlying premise. Whereas Companies Act, apart from that, the remaining everything will come under the Companies Act. And the company is not being liquidated to defraud any person. So my main point here is I am not trying to voluntarily liquidate my company under IBC, not to defraud any person. So I am fair enough, I am good enough, I am meeting everybody's obligations and everything. Whereas under 271, the main thing itself is fraudulent nature of the existence of the company itself. Or, you are working against the interests of the nation. That is what it is. Yeah. So this is about that particular amendment. Now there is another amendment in section 275. Subsection 2 was inserted. This we have already discussed. The provisional liquidator or the company liquidator, as the case may be, shall be appointed by the tribunal from among us the insolvency provisional. Since this subsection 2 of section 275 covers only provisional liquidator or the company liquidator for the winding up processes under 271 under the Companies Act, it is not covering the official liquidator. So never ever be under that impression that official liquidator shall also be an insolvency provisional registered under IBC. It cannot be. Only the provisional liquidator or the company liquidator. Now, let us see 280. Jurisdiction of the tribunal. The following section shall be substituted. The tribunal shall, notwithstanding anything contained in any other law for the time being in force, having jurisdiction to entertain or dispose of. Now, with this section, you please understand what our tribunal can deal with. What kind of cases our tribunal can deal with by virtue of the having this amendment proposed by the IBC itself. So, first thing, any suit or proceeding by or against the company. So, the company should be involved. So, any suit or proceeding either by the company or against the company. Any claim made by or against the company, including claims by or against any of its branches in India, or an application made under section 233, that is covering our fast track measure, or any question of priorities or any other question whatsoever, whether of law, of or facts, including those relating to assets, business, actions, rights, entitlements, privileges, benefits, duties, responsibilities, obligations, or in any manner arising out of or in relation to winding up of the company. So all these things, if it is in relation to winding up of the company, whether such suit or proceeding has been instituted, already instituted, or is instituted, or is such claim or question has arisen or arises, or such application has been made or is made, and the scheme has been submitted or is submitted before or after the order of the winding up of the company is made. So this is in all these aspects, the tribunal is having a jurisdiction that is specified under the section 280 of the Companies Act by virtue of the IBC. Then 15 to 17, it is all omissions only, because all these omissions, if you see, power of tribunal on application to for staying of winding up and voluntary winding up and entire voluntary winding up process, everything has moved to IBC. Since it is moved to IBC, all these sections were omitted under the Companies Act. Now let us see section 326, overriding preferential payments. The following section shall be substituted. What is that? In winding up of the company, the following debt shall be paid in priority to all debts. This is more or less 326 of Companies Act. You can compare it with our 53 under IBC. So first thing, workman's dues, and where a secured creditor has realized a secured asset, so much of the debts due to such secured creditor as could not be realized by him, or the amount of the workman's portion in his security, if payable under any law, whichever is less, pari passu with the workman's dues. Provided that in case of the winding up of a company, the sums referred under 1, 2 of clause B of the explanation, which are payable to for a period of 2 years. This is also same more in IBC. The debts payable under the provision to subsection 1 shall be paid in full before any payment is made to secured creditors, and thereafter the debts payable under that subsection shall be paid in full unless the assets are insufficient to meet them. And then here they have given the explanation for workmen dues. So workmen, for the purposes of Companies Act, is means an employee of the company being workman within the meaning of clause S subsection 2 of Industrial Dispute Act. So he's drawing the inference of workman definition from Industrial Dispute Act for the purposes of this Companies Act. And workman's dues, the workman dues also is explained very elaboratively, which is not the scenario in IBC. So here workman dues is like all wages, salaries, including wages payable for time or piecework or salary earned wholly or in part, etc., commission, etc., and all accrued holiday remuneration also. Everything is clearly defined for the workman use. And unless the company is being wound up voluntarily, merely for the purpose of reconstruction or amalgamation with another company, or unless the company has the commitment of winding up, under such a contract, with the rights capable of being transferred to or vested in workmen, all amount due in respect of any compensation, etc., under the said act in respect of the death or disablement of any workmen of the company. That means what? If at all any scheme of arrangement or amalgamation is there, because of that, that employee is moving to that other company and his rights are not getting affected, then there is no problem. You need not consider that as a workman due. Otherwise, it has to be treated as a workman due and for the purposes of section 326 under the Companies Act. So these are all the elaborated definition. Now let us see 53 also. Since we have touched upon 326 of the Companies Act, let us see how the 53 is functioning. Notwithstanding anything to the contrary contained in any law, parliament, etc., etc., the proceeds of liquidation assets shall be distributed in following manner. What is that? First, insolvency resolution process cost and the liquidation cost paid in full. Now, this scenario will be there in winding up by the tribunal under Companies Act. No, it will not be there. But here under 53, the first mechanism, waterfall mechanism, the first bucket is insolvency resolution process cost and the liquidation cost. Then comes the following debts, which is workman's dues for the period of 24 months, and then debts owed to secured creditor in the event such secured creditor has relinquished. Here he is clubbing workman dues along with the financial creditors, secured creditors dues, if at all they have relinquished their security and given to the liquidation estate. That is the second bucket. Then wages and any unpaid dues to the employees. Then financial debts owed to unsecured. Then financial dues shall rank pari between government dues or state government or the central government, and then etc. And then debts owed to the secured creditor for any amount unpaid following the enforcement of security interest. That is remaining any remaining debts and dues. Now, if the secured creditor has not relinquished and exercised his security, then whatever he is realized, the balance is falling under the last bucket. Whereas in Companies Act, it is not like that. That debt is also falling in the first bucket itself. So any remaining debts and dues, and then the preference shareholders, and then equity shareholders or partners as the last. And for this purpose, it is hereby clarified that at each stage of the distribution of proceeds in respect of a class of recipients that rank equally, each of the debts will either be paid in full or will be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. More or less, it is the same in the Companies Act also. But the term workman dues shall have the same meaning as assigned to it under Section 326. Simply what he has done, the entire elaborative definition given under 36 is simply made it applicable for workmen dues even under IBC also. That is the interplay between IBC and Companies Act. Yeah. So I'm moving ahead to the next amendment, that is 327. In 327, after subsection 6, the following subsection shall be added. Section 326 and 327 shall not be applicable in the event of liquidation under IBC. Now, this is a big question of conflict, I would say. In section 327, subsection 6, he says, after subsection 7, he has included saying that 326 and 327 shall not be applicable in the event of liquidation under the IBC. That means 326 and 327 is applicable for voluntary liquidation under IBC, but liquidation under IBC. Can we draw that kind of inference? Yes, appears to be like that only. And in the explanation, relevant data also, there is some reference here. Yeah. Now, what is that 327? We will say. In a winding up subject to the provisions of 326, they shall be paid in priority to all other debts. So the priority waterfall mechanism under Companies Act is like this. All revenues, taxes, cess, and rates due from the company to the central government or a state government or to a local authority at a relevant date and having become due and payable. That means the government-related outstandings, the payables, it is taking the first stage, the first bucket here. Then comes all wages or salaries, including wages payable to piece work, etc., etc. This is correct. Then all accrued holiday remuneration, the workman is given priority later. Then unless the company is being wound up voluntarily, merely the purpose of reconstruction, etc. Because in amalgamation, restructuring and everything, those people are moving to the other company, so their rights are not getting affected. If it is getting affected, then it has to be treated like this. Otherwise, it need not be considered under 327 mechanism. Another, yeah,
Sir,
another yeah,
what about liquidation expenses, sir? Like in IBC section 53, top priority
fine.
has been given to liquidation cost, which includes
Yes,
remuneration of the liquidator also. But
yes.
here, if at all empaneled IP, one of the
Hmm.
IP is appointed as company liquidator, in that
Liquidator, yeah.
case, what about the
Hmm.
remuneration, sir?
The
Will it
remuneration
not
will
be
be
paid as a top priority or?
no, it is not. There is a difference between IBC versus the Companies Act winding up. In IBC, it is left to the discretion of the committee of creditors if whatever been paid to the resolution principal can be adopted as a remuneration to the liquidator under liquidation process, right?
Yes,
And
sir.
for voluntary liquidation also, the companies are having some kind of discretion while they are appointing, they will fix that this is your remuneration for the entire voluntary liquidation process. Apart from that, based on the realization, something is there as per the IBC table. But when
Okay.
coming to the winding up under Companies Act, the tribunal itself is appointing directly. So that when the tribunal is appointing, the fee of the liquidator will also be fixed. So it is not an obligation or debt obligation to be met out of the winding up proceeds. It is like a mandatory payment, like how a remuneration has to be paid. That's how it is dealt with in winding
who
up
will
under
pay
Companies Act.
who will pay that amount, sir?
See, because whatever the winding up is happening on that company,
Liquidation
the
account.
company itself will pay directly first.
Okay.
Yeah, by virtue of an order, it is getting paid.
Okay, sir.
But under
Thank you.
IBC, there is no such order for the fee payment for the liquidator.
Initially, at the time of appointment for IRP, they are giving in the order itself. A payment of rupees 2
Yeah,
lakh should be paid towards
yeah.
the
That
publication
is under
cost and
CRP. Yes,
under
CRP they are giving.
CRP, yes, sir. Or that
Yes,
order is fixed.
liquidate. Yeah. Of late, they
Sometimes
have
even
developed
in the
this
liquidation expense, liquidation order also, sometimes if it is already decided by the COC, that is recorded in the order, sir.
they are recording in the order, and of late this scenario gets started. In the beginning the years of the IBC, that was not the scenario.
Yes, sir.
So, and IBC itself has not envisaged such a thing. It's NCLT, because the practical difficulty, these people are playing with the insolvency professionals, because all the insolvency professionals are becoming scapegoats. Without getting even a single rupee, they have to work. That is how the
Yes, sir.
situation
We'll
is
become
becoming now.
insolvent.
Yeah, we are becoming insolvent. Yes, rightly mentioned. So to meet such kind of situations, even though IBC is not envisaged anything, NCLTs are coming forward and passing such orders. But this is not the scenario under Companies Act. Companies Act, directly the tribunal will pass an order saying that this is your information and it has to be paid, whether you realize it or not. Yeah. Okay. Yeah, this is the mechanism under 327. Now, there is another section 329. Transfers not done in good faith to be void. The following section will be substituted. Suppose, let us see what it is. Any transfer of property, movable or immovable, or any delivery of goods made by a company, not being a transfer or delivery made in the ordinary course of its business, or in favor of a purchaser or encumbrancer in good faith and for a valuable consideration, if made within a period of 1 year, before the presentation of a petition for winding up by the tribunal, under this act shall be void against the company liquidator. Now see, this proposal is coming up from the 11th schedule of the IBC, which talks about only winding up by the tribunal. It is not talking about the winding up under IBC. That is first difference. Now, the winding up petition was filed before the tribunal within 1 year. What is that we are seeing? Suppose there is a transfer property, be it a movable or immovable or anything, and it has been done, which is not in the ordinary course of business and which is in favoring of the purchaser, then that has to be treated as a void. Again, as the company liquidator. If it is in a normal course of business and is done even within 1 year or beyond 1 year also, then there is no problem. It is not void. But otherwise, should be treated as void against the company liquidator. This is one section they have proposed. Yeah. So let me show you the other things also. Yeah. Till 20 we have covered. The other things I could not make it in the presentation, so that's why I'm showing you the main schedule itself. Now 334, the following section shall be substituted. What is that? Transfer, etc., after commencement of winding up be void. In case of winding up by the tribunal, any disposition of property, including actionable claims of the company, and any transfer of shares in the company or alteration in the status of its members made after the commencement of winding up shall, unless the tribunal otherwise orders, be void. So, suppose any kind of these transactions, disposition of property, etc., everything is happened. If tribunal passes an order otherwise, these things will be treated as void once the winding up is commenced. That is what this 334 says. Then 336 says whether by the tribunal or voluntarily or which is subsequently ordered to be wound up by the tribunal or which subsequently passes a resolution for voluntary winding up. These words are replaced by the tribunal under this act, which is subsequently ordered to be wound up by the tribunal under this act. So let us see what is that 336. I will show you the section itself. Yeah. Mainly offences by officers of companies in liquidation. This is what this section 336 deals. And here it is suggested by the tribunal under this act, or which is subsequently ordered to be wound up by the tribunal under this act. This is one change there. But now just see, if any person who is or who has been an officer of the company, which at the time of the commission of the alleged offence is being wound up, does not, to the best of his knowledge and belief, fully and truly disclose to the company liquidator all the property. That means he is not disclosing anything, and which is done in not in an ordinary course of business, then that is an offence punishable for on the officer who is of a company which is undergoing the liquidation. So there are certain things they have mentioned: does not deliver up to the company liquidator as he directs all such part of the movable or immovable property. That means some movable or immovable property of the company has not been disclosed or delivered to the company liquidator. Then also the punishment is there. So within 12 months, immediately before the commencement, at any time, he conceals any part of the property or of the company, or the value which is having 1,000 rupees or more. So he's concealing that much of value of the property, or fraudulently removes any part of the property, or conceals, destroys, mutilates, or falsifies. All these things, if any officer of the company which is going under liquidation, if he does these things, then it is a punishable offense before the tribunal. That is what it says. Now, let us see 337. Subsequently, pass a resolution for voluntary winding. What is that 337? We will see. Yeah, for the penalty for frauds. So, what are the penalty can be prescribed for such kind of false frauds is mentioned over here. If any person being at the time of the commission of the alleged offence of an officer of the company, which is winding up, has by false pretenses or by means of any other fraud, induce any person to give credit to the company. Suppose some kind of fraudulent activity and you are inducing some person to do that activity, then he is punishable. And with an intent to defraud the creditors of the company, or with an intent to defraud has concealed or removed any part of the property, etc. So all these things will come into the picture as for charging a living penalty for those frauds. That this 337 deals. Then 343. This is a big section again. Entire section is replaced. So let us see what is this 343. Company liquidator to exercise certain powers subject to the sanction. So there are certain kinds of restrictions are allowing this company liquidator, because company liquidator is the liquidator who has been appointed by the tribunal for winding up under the by the tribunal. So the company liquidator, with the sanction of the tribunal, when the company is being wound up, pay any class of creditors in full. He can do with the permission of the with the sanction of the tribunal only. So make any compromise or arrangement. Here also it is giving a power for the liquidator who is appointed under winding up by the tribunal. They also can do the scheme of amalgamation and merger, etc. So all these things, it is possible. Certain powers are given for the liquidator, company liquidator. That is what it has been provided by IBC to the Companies Act. Now 347. Where the affairs have been completely wound up and it is about to dissolve, the books and papers of such company and those of the company liquidator may be disposed of in such manner as the tribunal directs. Just it is a directive to the liquidator saying that how he has to deal with the books and papers of such company which has been wound up. There is nothing much in this. Then 348. It says if the winding up of the company is not concluded within 1 year after its commencement, the company liquidator shall, unless he is exempted from so doing either wholly or in part by the central government, within 2 months of the expiry of such year and thereafter until the winding up is concluded, at intervals of not more than 1 year or such shorter intervals, as may be prescribed, file a statement. So if it is not concluded within 1 year, he has to file a statement in such form. This is also the same scenario under IBC as well. But even for companies winding up also, IBC is proposing the same thing. Then 357. Commencement of winding up by tribunal. The winding up of the company by the tribunal under this act shall be deemed to commence at the time of presentation of the petition for the winding up. So here the commencement is defined like deemed to commence at the time of the presentation of the petition for the winding up itself. And 370, and the provision after obtained for the winding up by the company in accordance with the provisions of the act is inserted. So what is that 370? We will see. Huh. First of all, before me talking anything on this 370, you should understand this particular chapter itself. What is this chapter? Part 1, companies authorized to register under this act. That means you have, for general understanding, any partnership firm or any LLP or any cooperative society, etc., by following the procedure prescribed under this chapter, they can convert themselves into the company registered under the Companies Act. That is the main purpose of this entire chapter. So now let us see what this 370. All suits and other legal proceedings taken by or against the company or any public officer or member thereof, which are pending at the time of the registration of company in pursuance of this part. That means the conversion of that particular entity into the form of a company. If at all any suits or other legal proceedings are still existing, they will still continue in such manner as if the registration had not taken place. That means how it was there in before, the same rights and obligations are still will be there even after the conversion of that particular entity into a company. Now let us see what happens here. There is a proviso given. Execution shall not issue against the property or persons of any individual member of the company or any decree or order obtained in such suit or proceeding. But in the event of the property of the company being insufficient to satisfy the decree or order, an order may be obtained for winding up of the company in accordance with the provisions of this act or under IBC. Now conversion happened. Now suits and etc. everything are going on. Now there is an obligation on the company, that so-called the converted company, to make the repayments etc. or to meet the certain obligation. If something is not possible, either under Companies Act or under the IBC, then winding up can be initiated either under the Companies Act or under IBC. That is what this section says. Hope I am clear. Yeah. Then 372. Here also it is insolvency code is made applicable. So the provisions of this act are the IBC. With respect to staying or restraining any suits, the tribunal can stay the proceedings or restrain the proceedings either under this act or initiated under the IBC also is possible, because the tribunal itself, the constitution of tribunal itself, has the power emanated from the Companies Act, not from the IBC. So that is why IBC inclusion is here. Now let us see 419. The central government, by notification, establish such number of benches of the tribunal as it may consider necessary to exercise the jurisdiction, powers, and authority of the adjudicating authority. Since, as I told you, the constitution of the tribunal and its benches is emanating from Section 419 of the Companies Act, there the power of the central government, with the power of vesting with the CG, they can establish as many number of benches as possible, and also they can define the jurisdiction, powers, and authority, what it can do. That is under 419. Now 424, there are two changes. Under the provisions of the Act is replaced with, added with IBC also. So what is that 424? We will see here. Procedure before tribunal and appellate tribunals. So the tribunal and the appellate tribunal shall not, while disposing of any proceedings before it, or as the case may be, an appeal before it. Appeal because appellate authority is also here. Be done by the procedure laid down in the same code of civil procedure, or how it has to go to, and guided by the principles of natural justice, and are subject to other provisions of this act or insolvency and bankruptcy code. That means, plain understanding, the tribunals, what we deal, like NCLT or NCLAT, these two tribunal and appellate tribunal are supposed to deal with the matters connected with the Companies Act or the matters connected with IBC. No other statute will say that, under with the NCLT, you can make an application or petition, and NCLT has jurisdiction. So the tribunals or appellate tribunal, NCLT or NCLAT, is having jurisdiction only on the matters connected to the Companies Act or the matters connected with the IBC. That is what the IBC is bringing up here. So the tribunal and appellate tribunal shall have, for the purpose of discharging their functions under this act or under IBC, have the same powers vested in civil court, like summoning and enforcing, requiring the discovery. All these things can be done by the tribunal only with respect to the matters under Companies Act or under IBC. That is what this amendment says. And 429, the following subsection shall be inserted. So what is this 429? We'll see here. Power to seek assistance of the Chief Metropolitan Magistrate. Sometimes, our insolvency professionals may find difficulty to enter into the premises of any of the corporate debtor because those people will create some kind of troubles. These things happened in the very beginning of the IBC because they could not understand anything. Of late, this got reduced. But I myself, to mention here, I took this assistance in one of my assignments. So what it says, the tribunal may, in any proceedings for winding up of a company under this act or in any proceedings under IBC, in order to take into custody or under its control all property, because this is the duty of the liquidator, control of all properties, books of accounts, etc. Then in writing, we have to make an application. Then the chief metropolitan magistrate, chief judicial magistrate, or the district collector, within whose jurisdiction any such property is falling, or other documents of the company are falling, and such corporate persons under the said code are situated upon to take possession thereof, they shall pass, as the case may be, on such request, they can pass an order saying that you can take possession of such property and also cause the same to be entrusted to the tribunal or other person. This is what the amendment says under 429. Now let us see 434. What is this 434? Transfer of all the pending proceedings. You all know that before this tribunal got incorporated, there is a board called Company Law Board. So whatever the matters before the Company Law Board, those are all things have been transferred to the tribunal. That is what this clause A says. And then any person aggrieved by any decision of the CLB and had made an appeal before High Court within 60 days, so that from the date of commencement of decision or order of the CLB, then provided that the High Court may, if it is satisfied the appellant was prevented by sufficient cause, it will be dealt within the 60 days. That means even though the tribunal has come into existence, before coming into existence of the tribunal, some order was passed by the CLB, and based on that order, there was an appeal filed before the High Court because the High Court is the appellate authority for orders passed by CLB. Then that High Court can still continue with that appeal, and that need not be transferred to NCLT. That is what it says. And then all proceedings under the Companies Act 1956, because 2013, the NCLT has come into the existence even before IBC itself, because Companies Act 2013 is the originating or mother act which gives birth to the NCLT. Before that, CLB is dealing with all the matters under Companies Act 1956, and any matter with respect to scheme of arrangement, etc., everything which are pending immediate before such date, before the district court or high court, shall stand transferred. Here it is not talking about appeals. There are certain matters which are filed before CLB, and the scheme of measure, etc., we are not to be dealt by CLB, but earlier used to be dealt by High Court. So those transactions were transferred to tribunal because there is directly the tribunal is the empowering authority. Provided that only such proceedings relating to winding up of the company shall be transferred to the tribunal that are at the stage as may be prescribed by the central government. So at what stage and what type of companies can be transferred, central government has prescribed certain things. So this section speaks about those kinds of transfer of the cases which are pending before CLB or High Court, how it has to be transferred to the tribunal after this getting into existence. That is what this section deals with. Then section 468. So what this 468 deals with, let us see. Powers of the central government to make rules relating to winding up. Central government can make power, have a power to make rules with respect to winding up. That is, shall make rules consistent with civil procedure code, etc. Now the new act. And in particular and without prejudice to the generality of the foregoing powers, such rules shall provide for all or any of them. So what all that the power should be there, mode of proceedings, how the winding up has to happen, and holding of the meetings of creditors, how it has to be done, and giving effect to the provisions of this act for reduction of the capital, and all applicable applications, how it has to be made before the tribunal, and holding and conducting of the meetings of the creditors or contributories, suppose it is a case of amalgamation and merger, then settling the list of contributories, and the payment, delivery, conveyance, surrender, and transfer, etc., and papers to the liquidator, how all these things to be done, how we have to deal with the liquidator. So those powers and making the calls, etc., and the fixing of a time and which the debts and claims shall be proved. So on all these matters, central government is having a power to make rules. That is what this section deals with. And then there is a last amendment in Schedule 5. They have mentioned certain things where the company is a newly incorporated company for a period of 7 years from the date of its incorporation or a SIC company. So this is a SIC company for whom this scheme of reval, the entire thing has been transferred to the tribunal because the SIC initials and everything was transferred. Yeah. So with this, the 11th schedule is completed. So anything, any doubts members are having? With this, I'm concluding the presentation also. Any doubts? Are another 4 minutes we have so that I have completed well within time.
Yes.
Hope I am clear and made the topic highly understandable and made it lucid to all the participants.
Yes, sir. It is useful, sir. Thank you, sir.
Thank you. Thank you very much. Thank you.
So, any new faculty will continue the second half or
Yeah.
what, sir?
Yes. Second half, new faculty, another faculty will continue.
Okay, sir.
I
Thank you,
think.
sir.
Yeah. Anjali, you can give the inputs to them.
Thank you very
Thanks,
much,
sir.
sir,
Thanks.
for sharing your valuable time and sharing your knowledge and experience with the participants. The session was very interactive and wonderful. And the participants, now there is lunch break. New session will start at 2:30.
Yeah.
Okay, ma'am. Thank you, ma'am.
So with that note, I am conveying my thanks to all the participants for having this wonderful interactive session. And thanks for the ICSI, IIP, and Anjali for giving me this opportunity to deal with all of you. Thank you. Thank you, one and all.
Thank you, sir.
Avil sir, shall we start? Avil sir, are you here?
Yeah, I'm there.
Shall we start now, sir?
Yeah, we can start. I'm fine.
Yes. Good afternoon, everyone. Now I welcome you to the workshop on the topic management and leadership skills for IT and role of CA under IBC. Let me briefly
Good afternoon,
introduce.
sir.
Yeah, good afternoon, sir. Seeing all familiar faces.
Sir is member of ICAI Excellence in Law, MCOM from University of Mumbai, registered IP and Bangalore. He has more than 20 years of experience in finance and banking sector. He has good exposure to various debt restructuring schemes notified by RBI for stress companies and resolution and liquidation process under IBC. He is a regular speaker on various forums on topics related to IBC and has been trained by IBA Train the Trainers program. He is currently handling large exposures both for insolvency resolution and liquidation. Here to start with this session.
Yeah. Thank you, Madam Anjali, for that kind introduction, and good afternoon to all the participants, fellow professionals. I think I'm seeing a lot of regular names. I'm quite privileged and honored to be a part of this session. I think it's not a one-way traffic as we generally have, but I think we can always have an interaction in terms of question and answers. While I'll encourage you to ask question and answers, I think that's what, as IPs, I think a lot of information sharing, knowledge sharing is what regularly happens at various forums. So I think with that, the topic for today, which I am going to take is management and leadership skills for IPs, role of a chartered accountant under IBC. So what are the various roles which ACA can play under IBC? I think all of you are IPs and have handled quite a few assignments. In fact, I was one of the earliest insolvency professionals to have registered with the IBBI and have been fortunate to have been assigned the role of an IRP/RP liquidator in quite a few assignments. And what I would be sharing today is more of my personal experiences, more of my personal knowledge. I think everyone is an IP over here, so I think everyone understands what IBC is all about, what skills it entails, what are the risks, rewards for a individual insolvency professional, and of course, what are the allied activities that as an IP we are supposed to do. So this is what the presentation flow is: management and leadership skills for IPs, a role of chartered accountant under IBC. So as far as insolvency and bankruptcy is concerned, it's almost 8 years since the enactment of a code, and it's a paradigm shift in the way of insolvency regime was there. As many of the participants are themselves practitioners and are aware that insolvency laws in this country were scattered across various legislations and regulations. What IBC did was to provide a single platform to get insolvency resolution for corporates, LLPs, for individuals, partnership firms on a single platform, which is under the Insolvency and Bankruptcy Code. A lot of allied laws which were there, the BIFR, SICA, were all repealed. A lot of changes have been done to some of the laws, the Presidential Crown Insolvency Act, all those were repealed when IBC code came in 2016. The idea only of the code was a time-bound mechanism to resolve the stress. Of course, there are a lot of other avenues which are available to any creditor today to resolve apart from IBC, but IBC was one of the favorite tools which was used by the lenders, primarily because it was a creditor in control regime. In our country, any resolution or restructuring mechanisms were always led by the promoters and were handled through the creditors in with their assistance. Nothing could have happened. But since insolvency came in, since it's a creditor in possession rather than a debtor in possession, I think the way the behavioral change as far as a debtor and a creditor changed, and I think everyone has experienced the resistance which initially was there when IPs were taking over assets, taking over companies, trying to run management. A lot of people did think that IPs may not be capable. I think sooner or later, people started understanding how a resolution is going to play out, what is the role of an IP. Earlier, IPs were known to have a lot of powers, but later on, a lot of jurisprudence did evolve. And as far as an insolvency professional is concerned, when he wears the hat as an IRP or an RP, he's only a facilitator of the process, more in an administrative role. The entire roles of the insolvency professional in the roles of an IRP or an RP are governed and controlled and supervised by a large extent to the committee of creditors. In contrast, when we see the liquidation process, the liquidator does have a free hand. Initially, there was no concept of a stakeholders consultation committee, which has now come in because of a lot of decisions that were taken by liquidators, which the stakeholders did not agree to in totality. However, most of the liquidators were trying to work within the parameters of the law. But I think the introduction of an SCC was a very welcome step, which the regulator has gotten. So at least we do discuss with the lenders. Earlier, there was no mechanism of taking a vote, at least now on very critical decisions, whatever has been enshrined under the liquidation regulations. Even for those matters, voting are done by the secured creditors. So a liquidator is more in a quasi-judicial capacity, has much higher powers than compared to a resolution professional or an insolvent interim resolution professional. So every role entails a lot of powers, entails a lot of responsibilities. As they say, with great power comes great responsibilities. So it's very important for an insolvency professional to uphold his responsibilities and duties under the act. What we are here is only a bridge between the creditors and the incoming investor. In between, our job is to stabilize the ship, try to prevent leakages wherever it is possible, and try to run the operations as a going concern, because everyone understands that a factory which is running has a better chance of sale or of a resolution of a company than a factory which is closed. However, we've seen different experiences. Everyone would have their own experiences, but largely everyone would agree that an operational factory would fetch a better value. We would be able to sell it much faster as compared to a factory which is shut. However, there are takers for all sorts of assets in the market, provided we market it correctly. So one of the facets or one of the preambles objectives of the code was a time-bound mechanism. Prior to introduction of IBC, significant delays were there, especially in BIFR and SICA. But in IBC also, of late, a lot of litigation has ensued, but to a large extent, I think most of the matters have been settled. So IPs are in a position, as I would say, and I always keep on saying, in concluding a process in a time-bound manner. Of course, everyone would agree that 180 days is too short a time. The regulator is pushing us to close cases within 180 days. But practically, if you see, it becomes a little bit challenging, and that's my personal experience. I'm not saying that that's the norm, but 270 days is a very realistic time for getting a resolution done. Or in the absence of that, you can always take the company to liquidation. Another important objective where RPs play a very important role in the CIRP process is maximizing the value of the asset to all stakeholders. The most core objective, as I understand, under the code is resolution. But along with resolution, there is also recovery, because for any resolution plan to go through, recovery is one of the predeterminants which the committee of creditors and other stakeholders are going to look at, who is going to get what. And that's where the principle of maximization of value of the assets for stakeholders. Over the last 7, 8 years, different mechanisms for bidding have been taken into account. There have been cases where multiple rounds of biddings have also been allowed by the Committee of Creditors, which has been upheld by the NCLT and the NCLAT, saying that the creditors can take all actions for maximizing the value of the assets of stakeholders. But the fulcrum of the entire process, the person who is driving this is the resolution professional who's thinking out of the box, uh, advising the COCs, the Committee of Creditors, on what is the right approach to take this forward. Earlier, when challenge mechanism used to take place, it was more of a physical rounds, which we had seen in the last 2, 3 years when challenge mechanisms were run by IPs. But currently, we are also seeing online. There are a couple of portals which have come on and which facilitate online value maximization or inter se bidding amongst participants, even in a CIRP process. We've used it quite effectively in the last couple of months to maximize the value for stakeholders. So it's important for an insolvency professional, be it an IRP or an RP, to think about ways and means of trying to derive value of the underlying asset. We all understand and we all appreciate that what you see is what you get, while the expectations of the lenders to a large extent may be categorized as unrealistic, but at the same time, we also have to understand that there is an investor on the other hand who's trying to minimize the value of the asset, sometimes aided and abetted by the current management, erstwhile management, the promoters. So RP being the fulcrum of the entire process, it's our singular responsibility to help the stakeholders in maximizing the value of the assets. In some of the cases, I mean, we should also think out of the box in terms of what sort of resolution mechanisms can be adopted. A lot of times, the members who sit in the Committee of Creditors may not understand that what is available to them in terms of the code and the applicable regulations. So the RP has a very important role in educating the Committee of Creditors to use equivalent or requisite mechanisms under the code. Now, to give you an example, Regulation 29 of CIRP. Now, uh, this is a very good regulation which can be utilized for monetizing some of the assets during the CIRP period. While we've done this in a couple of cases, but a lot of creditors are not aware. So Regulation 29, it actually enables the resolution professional in consultation with the COC to sell any unencumbered asset, which is not in the normal course of business. So if you have an asset which is an unencumbered asset, that's the first condition is the asset should be unencumbered. It should not be charged to any lender. So that can be sold during the CIRP process, and which is not in the normal course of business also, because in the normal course of business you sell inventories, realize receivables, etc. But at the same time, the book value of this asset should not be more than 10% of the total claims. So you can use Regulation 29. We've used this in a couple of the assignments where these were non-core assets. In one of the cases which I was the RP in early 2019, we had a stake in a smart city project where we were 51% stake and 49% stake was another company, which was one of the large companies. When they came up saying that we would want to buy this asset, so the lenders were saying that no, you'll have to enter into the CIRP resolution process. But at that point of time, we did point out saying that Regulation 29 of the CIRP will help in this regard. And that asset, if it would have gone in the normal course, would not have fetched more than 3-4 crores, because that was the value of the asset. But since this was a person in need, we maximized that value and we derived 13 crores. This was approved by the Committee of Creditors, and this was kept in a fixed deposit to be distributed along with the proceeds of the resolution plan. Very recently, I am the resolution professional for a company called Future Enterprises Limited. Now, this was more of a holding company of the Future Group, one of the holding companies, I would say. This also had a different sort of asset. So it had an insurance asset. They had 24% stake in Future Generali Life Insurance and non-life insurance. While there was an IRP who was appointed in the process, he had started the earlier process for sale of the corporate debtor as a going concern, where we had received resolution plans which were not to the liking of the COC. And upon my appointment as RP, we took forward that process in terms of negotiations. But since the negotiations were not going anywhere, we suggested to the COC that why don't we look at a cluster-based approach, because this was a very classic case of a company being a holdco, also having operations, diversified investment. So anyone who understands insurance, there are very few players in the insurance segment, more of financial or strategic investors who would participate. It's a capital intensive industry if you're at the startup phase. So this was a stake which we had almost 24%. It was unencumbered because IRDAI, the regulator for the insurance, does not allow marking lien or pledging these shares which are holding insurance companies. Because at the end of the day, they will also have to look at the investors in terms of fit and proper person. So this was not allowed. So these shares were unencumbered. We had roughly claims which ran into thousands of crores, and the book value of the assets were negligible. Since it did fit in that, we suggested to the COC that along with the cluster-based approach, where we had bifurcated the company into three clusters. One was the insurance asset. Second was a stake which we had 39% in a textile unit. So along with the National Textile Corporation, which is the government of India enterprise. So this was a scheme for upgradation of textile mills. So there were two textile mills which we had in the heart of Mumbai. So these were more strategic investment as far as textiles were concerned, or it was a real estate play as it would eventually play out. So this was another cluster, and the balance was the rest of the company. So we also ran a regulation 29 along with the cluster approach, and we did get sizable interest both for cluster approach as well as regulation 29. So finally, under regulation 29, we sold this. Now, since this is public information, we sold this to Central Bank of India, and they have now replaced future in the future generally insurance, both life as well as non-life. A very interesting thing which we did in this case was, since the CIRP is continuing and we had we had generated almost 508 crores from sale of this asset, the COC also thought about why don't we distribute this money, and we went to the NCLT for an interim distribution. Now everyone understands that there is a moratorium, and during a moratorium you cannot distribute any money to the creditors. While there are few examples of the few examples, I would say only one precedent in the case of KSK Mahanadi, which also happened in the last 6 months. I believe the second example is Future Enterprises, where this money of 508 crores, we went to the NCLT and sought for an interim distribution. So generally an interim distribution would work in a manner where the COC would then approve the priority payment. So what happens to the operational creditors? What happens to statutory authorities? What you do is you distribute the money as per the priority under section 53. So you strictly follow section 53, where CRP costs are paid in full, workmen, gratuities, PF, etc. are paid in full. So it strictly follows section 53 of the code. So this is something which we did, as far as one was the requirement from the creditors that can we distribute this money rather than waiting for the entire resolution process, and also a cluster-based approach. So it is, so the point that I was making is, it is one of the paramount duties as an insolvency professional to see where there is value and where do you assist in maximization of value. So all these are skills which as an insolvency professional, we would imbibe along the way. I mean, nothing, no one learns it. So it's basically trial by experiment. It may have worked in some cases, it may not have worked in many of the cases. But our job is to ensure and try to understand the asset. At the same time, we also have to understand the mindset of the creditors who are there and try to bridge the gap as far as what we want to do in terms of value maximization, how to balance the interest of all the stakeholders. Now, balancing the interest of all stakeholders is also very important. Many of you are very seasoned insolvency professionals, and you understand when the distribution happens under a resolution plan, it's very difficult task to balance the interest of creditors, especially if your COC has a large number of unsecured creditors. So everyone understands that 66% is the threshold. So if unsecured creditors have more than 34%, they have a blocking right. So the secured creditors cannot try and attempt to get a resolution and try to maximize their own interest. So balancing the interest, especially in the distribution where the COC is concerned, is also a very challenging process for insolvency professionals. While some of you all may also say that, oh, it's not my role. Section 30, subsection 4 very clearly says that it is for the COC. When it approves the resolution plan, it will have to also speak about distribution, taking into account the security interest of the creditors. However, having said so, I think everyone also realizes that unless you say something, unless you put something on the table, it is very difficult that creditors may be fully aware about what their rights are under the code. So it's very important for an insolvency professional to understand the legal aspects and also have to have those balancing skills where you protect the interest of stakeholders. Again, if I give you the example of future enterprises, we have a large amount of fixed deposit retail holders. Now, they have roughly a claim as we speak today of around 51 crores, and they want full payment of their money. While they are writing to SEBI, they are writing to stock exchanges, they are writing to the finance ministry, they are writing to RBI, they are writing to IBBI, they are writing to all the enforcement agencies just to try and get their money. Of course, we will have to be sympathetic. I mean, there have been numerous discussions, calls that we had. So what we also did was they felt that their AR may not be effective in voicing their concerns. So with the permission of the COC, we called 4 or 5 FD holders as representatives to put their case in front of the COC. So while you may say that the law doesn't allow it, but you will have to empathize with the creditors who've lost money. And if someone wants a chance to speak with the COC, and if it is allowed by the COC, it's always better to have that. Now, there were FD holders meeting, which are regularly done by the AR, where he calls upon the RP, where he also calls upon some of the COC members to explain, because people may not understand the law. People only understand that they have lost their money and this promoter has siphoned off. RP is not doing anything, AR is not doing anything. The secured creditors are trying to maximize their own interest rather than the interest of unsecured and retail creditors. So it becomes very challenging for an insolvency professional to navigate through the entire process. So navigation through the entire process, not only for the company, as the code also says, it's an orderly and easy exit, but also for the IP. Everyone also knows that the regulator is very harsh on insolvency professionals. I think even for procedural aspects, we've been pulled up, leave aside other issues. But even for procedural aspects, I've seen RPs being reprimanded, RPs being warned, RP negative comments have come in the disciplinary orders, suspension, cancellation of license, so on and so forth. So an orderly exit for the company as well as the IP is also one of the key skills that IPs will have to equip themselves. So we all have to understand our roles and the skill set that is required in relation to the objectives of the code. Unless and until the objectives of the code are met, I mean, any sort of a win may not be a complete win, because the code does expect that the resolution happens. If a resolution happens in 5 years, I mean, that's a problem. The resolution has to happen in a time-bound manner. May take a year, may take a couple of years, may take 5 years also, but it should not be on account of the resolution professional's mistake. That's what we have to ensure. So a lot of legal skills, understanding the legal framework, thinking, strategizing along with legal consultants, hiring a proper team, that is also very important. Sometimes you may only hire an L1 because that's what the COC wants. You may have to tell the COC that fine, I may go with the L1, but he may not have the requisite skills. So the point is to tell the COC also the types of advisors which would be needed. And trust me, in many of the cases I've seen, almost in my 90% of the experience has been that the committee of creditors are very reasonable, very rational and commercial people. Of course, 10% of the time there is a tug of war in terms of what should be the cost, what is the outcome. Now, no one can guarantee the outcome, but at the same time, the efforts which are made by you as an insolvency professional will have to be seen. So what is the role of an insolvency professional? Managing the going concern operations. So this is one of the most important roles that we have. So understanding the operations, understanding the numbers, all your skills. It's a minimum of 10 years if you're a chartered accountant, company secretary, cost accountant, or an advocate to get an IP license. So you have sufficient experience. If you don't have these four qualification, then if you're a management graduate having a management experience of at least 15 years, then you get a license. So people who come with this sort of skill, this sort of caliber, this sort of experience have worked in various institutions. Some of them have led their own businesses right from day one. They're into practice, they're into consulting, they're into audit. So people have seen with this sort of experience the kind of skills that it takes and the kind of efforts that it takes on the part of the resolution professional and his team. So as an RP, I mean, most of us, including me, were armchair professionals. We were all sitting and giving gyan, and we used to give out reports, opinions, saying, "Acha, ye kar lo, wo kar lo." Now, the point is you have to do it, you have to show it. So the ball is in your court now. And at most of the occasions I've said, I mean, an IP is a promoter without any investment. So without investing, you have got a factory to operate. Does not mean that you take decisions left, right, center. You always have a team. It's always important to delegate, understand the operations. We may not be experts in all the field, but the company who's running, sometimes the promoters are cooperative only because the employee, there are a lot of workmen, there are 300, 400 families at stake. So the promoters are sometimes cooperative, but you will have always a middle management or the top management who may not be from the promoter group, who are always there to assist, understand. So their cooperation, their full support to the RP would only happen if you are in a position to understand the operations and the numbers. You just can't say, "Okay, deliver." You will have to understand. So managing going concern skills, this is one of the most important skills that we should have as resolution professionals. Everyone understands the process. Everyone understands the code. You may have legal professionals to assist you, but handling operations, handling people is a very important skill. If you speak very rudely, if people may not like your tone, if people may not like your working style, if people may not like you as a person, for whatever would be their perception. So perception management is also very important. So a lot of ruckus can get created because of disgruntled employees, unpaid workmen, a hostile promoter, and a tough COC. A lot of time committee of creditors also unrelenting. So for a IP, you need to have people skills. You will need to explain to the creditors that this is what can be done, this is what cannot be done. To give you an example, in one of the cases, the creditor said, "Why don't you shut the operations?" I said, "I am willing to shut the operations, provided you pass a resolution." How do I shut operations? Because the operations are ongoing. If the factory shuts, if the employees go on strike because salaries have not been paid for 2 months, 3 months, naturally people strike, factories may close down, or you start taking some advances from customers, trying to manage the show. So various ways and means can be done, but shutting a factory is a very difficult decision, because at the end of the day, as an IP, if you are taking the decision, there are labor laws in this country, and you may have to give retrenchment compensation. You just can't say no work, no pay. No work, no pay will only come when the factory is not operational. You may try to restaff, do an appropriate staffing strategy. Sometimes it works, sometimes it doesn't work. In one of the cases, we did try to uh, ask some of the people not to come and probably put them on a 20% basic salary, so that at least the basic needs are taken care of. So you'll have to do all those uh, mix and matches and try to navigate through the entire situation. If you're not able to handle the operations, then it will become a lot of challenge, because a lot of your time, personal time, will get invested. You may not be able to handle the process very effectively. You may not be able to handle the creditors, because a lot of creditors are also demanding in terms of information. If some information is needed by their head office, we all know how creditors do push the RPs to give information in an hour, 2 hour, 24 hours, 48 hours. So they have their own deadlines. So we all have to work with deadlines. So people skills is one of the most important skills, which I believe helps you in navigating the entire process from day one to day 100. Today, day 100 means the last day of the CIRP process. Whether it goes into liquidation or it gets resolved, at the end of the day, you will have to manage the show till the time you are there on the seat. So navigating the entire process, taking people along is very important. So in most of my cases, what I do is I have this meetings, periodic meetings with the top management. We have this WhatsApp groups for information exchange, and periodically, maybe once in 2 months, once in 3 months, depending on the need. We also have town halls to just to ensure that all people are aligned in terms of where the process is on. Otherwise, sometimes even the smallest of the issues may lead to strikes. People just sit on strikes for 10 days, 12 days, 15 days. Some of them threaten that we'll put this on YouTube, we'll call the media. So all these then would become unnecessary headaches. So setting out the expectations right from the beginning is very important for an insolvency professional to handle the operations, to handle the going concerns. If the factory is shut, I think most of us would be at least happy saying that, at least this aspect of the job is less, because a shut factory may not entail much of management bandwidth, not much of skills which are required, except for seeing the security, insurance, etc., that everything is there and nothing gets stolen or there are no thefts, etc. But if it is an operating company, trust me, I mean, you will enjoy the process. You will enjoy understanding how the business operates, the small nuances which comes in terms of the compliances, the sales process, the purchase, etc. So understanding operations, understanding numbers is a huge part of the IP's responsibilities. Everyone who is a professional will obviously understand the numbers, but I think most of us do have a challenge in understanding operations. But sooner or later, I think we do get a hand of it. We understand who are the key people whom to trust for advice. So the entire process is about navigating, engaging, and to a large extent delegating. So all skills, I mean, you will never have. So it's always better to trust the process and delegate it to the management team. That's also a very important aspect and a very important skill, because trust takes time. And since trust takes time, trust is always done basis the conduct and not basis the words. So even though there is a CEO or a CFO, obviously for me also it takes, I mean, I tell them very upfront that what you, if you say something and I see something else, I mean, that's going to be a very difficult situation. So it's always important to tell them the expectations right. So always meet them in the first 3, 4, 5 days or in the first weeks, address their questions, because a lot of them will have a lot of questions. What happens to this? What happens to our salaries? What happens to X? What happens to Y? So the first 1 month is very crucial, and that will help you to navigate the entire process. So delegating to the right people, trying to trust them, because many of these people have worked with the company for 5 years, 10 years, 15 years. In some instances, we have people working who are at the fag end after retirement. They've been engaged as consultants. So they have an affinity and a loyalty to the company at the end of the day. And they also would want to see the same in an RP, that you are interested in the interest of the company. You're not here only for your monthly fees. As is told, a lot of COC members will also accuse saying, "Aapka to paisa mil raha hai har mahine." This is what even the management will say, "Aap baithe raho, paisa mil raha hai." That's not the way one looks at work. One looks at it very seriously from a from a perspective of moving out of the assignment. Because in all my assignments, I say that if someone is temporary, it's me. I have taken over from the erstwhile management because there is a court order, and my job is to hand it over to the incoming management, be it a promoter under 12A or a promoter if he is an MSME and is eligible under Section 29A, he can take back his own company. So setting expectations right is very important. And since I said trust takes time, but you'll also have to trust the process and trust yourself sooner, trust the people sooner. Otherwise, if you take 1 year to trust, it's going to be a huge, huge challenge. Once managing the operations requires a skill, managing the CIRP and the liquidation process is also another skills. Now we all understand that there are frequent changes to the regulations. The code has not been amended, but I think in the winter session, there is going to be an amendment as far as the code is concerned. There are a lot of cases. Someday we are hit by technology board. Someday we are hit by a rainbow paper. The other day, we are hit by a Paschimachal. Currently, we are hit by the Bhushan Steel judgment. The entire ED conundrum is out. So you have to manage the process. Your resolution plan is currently being put to vote, but IBBI now says that in the information memorandum, you should have shown all the PUFE transactions which are there. So how do you navigate and manage the entire process? Because you just can't say that, oh, I skipped this regulation, because the regulator is going to come down very heavily on you in case these are serious lapses according to their perception. So managing the basic process, basic timelines means 180 days means 180 days. I mean, you can't take the liberties to say, okay, 180 days, 10 दिन delay chalega. So your CIRP should not end. Your application for extension should be filed well within time. You cannot call for a COC after 180 days and seek an extension for 90 days, because that is clearly against the rules. So any extension, exclusion application which has to go to NCLT has to go much before the timeline. So managing the basic process timelines is very important. I hear from a lot of fellow professionals now saying that we have become more of compliance managers and less of insolvency professionals. But so be it. I mean, you will, if you handle multiple assignments, you will get a flavor everywhere. And trust me, I mean, I would say this from personal experience. The growth that I've seen in myself in the last 6-7 years of being an insolvency professional is tremendous. Your confidence increases. Your approach is really different. The way you speak with people, most of these promoters whom you meet today, or at least I meet today, meeting them 10-15 years ago would be at least taking months. You may have to wait out of their cabins for at least 2 hours, 3 hours, 50, so on and so forth. So the confidence to deal with them, the confidence to speak with them, they respecting you is also very important in how you manage the entire process, in how you conduct the entire process. So compliance and legal skills is also one important aspect and a skill which has to be developed by most of us. Compliance, of course, is burdensome, but compliance is a necessary evil. You cannot run away from compliance. Sooner or later, it is going to catch you. So it's always better that we keep the basic hygiene as far as compliance in all aspects to the best of our ability and on best effort basis. Legal skills is something which you will have to imbibe. You might be the best manager, best leader, but unless you understand legal, you have some basic interpretation skills, it's going to be a tough challenge looking at very complex matters. Even in simple claim verification process, I mean, a lot of these legal skills will have to be done. Imparting these legal skills to your team is also a very important aspect of your own team management and team building capacities and competencies. Managing the entire resolution process, liquidation process. So this is the role. I mean, crucial skill sets are required to bring in consensus. As I've already said, that committee of creditors becomes very difficult to handle. Uh, Telling people, operational creditors, employees, workmen, statutory authorities that you are only going to get, say, 1%, 10%, 15%, 20%, whatever is that percentage out of an approved resolution plan, or in most of the cases, zero recovery in the case of liquidation, because the waterfall as per section 53 sets in. So to get these consensus, to deliver these messages in writing, a lot of times I get complaints from a lot of creditors saying that we don't understand what you write. uh, Fairly so, rightly so, because because my job is more of commercial as well as legal. That is what I try to explain. So if there is a provision which I may have to quote, I will have to quote, because I have no choice. I cannot run away, because tomorrow when I'm hauled up to the courts, that point of time, they are going to see the communication and the records which have been maintained during the process. So getting consensus, trying to simplify the language in communication is also another crucial communication and writing skill sets, which many of us are honing day by day. One of the most important aspects, and this is what I speak very regularly, is that you have to wear the hat of an investment banker during the negotiation process. You cannot leave it to the COC, or at least that is my experience. But at the first instance, you'll have to give the chair to the COC members to negotiate. So whenever resolution plans are opened, whenever negotiation process starts, I upfront ask the COC members who is going to lead the negotiation with the PRA, because that is not the job of the RP. If you have process advisors, we would want them to lead the discussion, or if one of the lender wants to lead the discussion and bring out the points as far as the resolution plan is concerned, value pockets are concerned, they are free to do that. But in all my cases, and invariably I've seen, they say, no, you start, you set the ball rolling, you raise all the points, and thereafter we will, whatever is balance or whatever we think fit, we will come. So investment banking skills is one of the most crucial skills that an insolvency professional must have. You need to understand your asset, because someone who is sitting at the other end of the spectrum, including their advisors, their legal counsels, would want to bring the value down by punching holes. And unless and until you understand the asset, you understand the nitty-gritties, the complexities, how these things will be undone, you will never be able to sell this to RA at the appropriate price. You may always say that I'm doing a bidding process, but prior to the bidding process, we undergo multiple iterations of the resolution plan, multiple iterations of the commercial value upgradation enhancement exercise. So this is something which I keep on saying, and I'll repeat it today, that in IP, wears the hat of an investment banker during the negotiation process. At that point of time, you should very clearly tell even to the PRAs that I am negotiating on behalf of the committee of creditors, because although my job is to maximize, but negotiation, throwing a number is not something which is a part of my profile or a part of my responsibilities under the code. Vetting of resolution plans to bring in certainty in the outcome of the process. So resolution plans. Now, in one case, a very recent case which went into liquidation, unfortunately, because the resolution plan was too complicated. We kept on telling the RA that this is not a 1,000 crore resolution process. You are giving me a double-digit number, and if a double-digit number is to be accepted by the committee of creditors, at least keep the plan very simple. Keep the plan simple. You don't need to add jargons. You don't need to do complex structuring as if this is a 1,000 crore asset. So these requests fell on deaf ears. I mean, at least 6 to 7 instances we had physically called him to the meeting. We had physical meetings also, but somehow or the other, he just didn't budge. And that company went into liquidation. One, because the value was near about the liquidation value, but the lenders were okay with that also, provided the plan became very simpler. So vetting of resolution plan, because sometimes they doubt the intention of the RA, because he may write something and tomorrow, based on interpretation, he may go to NCLT and the process may get delayed. So for the RA also, sometimes for them taking the company, taking over the company as soon as possible is in their best interest. Sometimes they just want some more time to go through. Maybe the company, the industry is going through a downward cycle. They might see the green shoots in the economy maybe 12 months from today. So they would also want to try and implement the plan as delayed as possible. So of course, the COC as a body also has their own legal counsels, but as an insolvency professional, you are supposed to read the entire resolution plan just to see that there is clarity in terms of implementation. One, in terms of the quantum of money which the creditors are going to take. And second is the certainty of the duration. It should not be a plan which is conditional. A conditional plan, as we all understand, as per the EBIC's judgment, is a non-compliant, but very clearly the EBIC's judgment also differentiates, saying that there should not be conditions which lead to walk away. So you can accept conditional plans. We have accepted conditional plans in our cases also, but these plans are not walk-away plans. Otherwise, this would become non-compliant plan. Avoiding needless litigations and ensuring quick disposal of assets claims in the liquidation process. So as an insolvency professional, your job is to have certainty in the outcome. As a liquidator, your job is also to quickly dispose the assets at whatever price the lenders and you agree based on the valuation, based on the market interest. Your job is to quickly dispose of the assets. In most of the liquidation cases, especially of infrastructure companies, there are huge amount of receivables, there are huge amount of arbitration claims. In most of the infrastructure companies, you may have a huge amount of bank guarantees which are outstanding. So assisting in recovery of this is also a very critical part of the liquidator's role profile. So as an IP, you'll have to understand what exactly you need to do in this particular case in terms of litigation, or in case you can meet the counterparty and try to convince, negotiate with them, try to come at a settlement. That is also something which is vastly appreciated, because at the end of the day, people look at recovery. And that's exactly the role of insolvency professionals. You're not administrators, but we are key drivers of value maximization and resolution. I will just stop at this moment and ask if there are any questions from any of the fellow participants, fellow professionals. Do you have any questions? Otherwise, it's becoming a monologue. Fine. So in case there are questions, please feel free to ask them. So the IP's role is a multifaceted role. As I've said, you wear the hat of an IRP, RP, liquidator, and a bankruptcy trustee. At each of these roles, your responsibilities, your skill sets which are required for the role is vastly different. As an interim resolution professional, your job is to first take control and custody of the asset, invite claims, and form a committee of creditors. So the first month becomes very important to take effective control, effective custody, tell the promoters, tell the management that yes, IRP is in the seat, the IRP is in the saddle, he is the one who calls the shot. So your leadership skills are quite evident when you are an IRP. You don't need more of process skills at that point of time. So the first month is more about management, leadership, engaging, be the guy on the ground, because unless you're there on the ground, it does not inspire or instill confidence from the workers, from the employees. When you walk past that factory gate or that office gate, you will have to walk with that realization. There are a lot of people who are waiting with hope that an IRP has come and he is going to resolve this company, is going to take us out of this mess. Everyone has loyalty towards the company. There may be a personal loyalty towards the promoters, but in my interaction in my last 7 years of experience in working as an IP, most of the people have told me, while personal relations are personal, their loyalty is first towards the company and then towards the promoter. So everyone sees that hope in you of you doing something, trying to stabilize the ship, try to navigate the process. And with the support and participation of all the people, you will have to take the first month to its logical conclusion by formation of a committee of creditors, ensuring that the COC is a representative body. Of course, the COC will decide whether you continue as the RP or not. So that does not mean that you include people into the COC or exclude people who may or may not vote against you. So that's not something which is expected of an insolvency professional, or that is not what is expected of this profession. But the first role, the first glimpse is more of leadership, less of management, more of crisis management, and too many decisions to be taken in the first month itself. So as I've said, once you walk past that factory gate, there is the security guy. You need to see who are these people, because IBC is not about claims, it is not about numbers, but it is about people. So having that empathy, having that leadership quality within you is very important. I'm not saying that we should just go as heroes, saying that, oh, I am the savior, I am the messiah. That's not the idea of telling you to be a leader. The idea is to speak with authority, tell them that you are in control, you understand the process. They also check your background. So they also know the kind of work that you have done. And if this is your first case, a lot of efforts will have to be done. It's not that they have no choice, right? You are forced upon them. It's always important for you, even if it is your first case, to tell them that I know my job. I'm here to assist. I'm here to navigate the entire process, and I'm confident of a successful resolution. Whatever are your issues, I will be in a position to resolve. So that's very important for an IP to demonstrate by actions, by words that you are in control. So leadership skills comes handy in the first month when you are trying to take charge, trying to stabilize the ship, trying to speak to a lot of people uh, in the company, outside the company, because a lot of people are curious on how the process is going to go forward. So communication is also very important. You need to be an effective communicator. I remember in one of the factories that I visited very early on, there was a strike going on, and I was asked to address them, almost 425, 430 people sitting there. And I started, so they all started shouting. So I said, what? I can speak in English, I can speak in Hindi. Of course, I'm a Christian, so I speak Konkani, but I can also speak some amount of Marathi because born and brought up in Mumbai. So everyone shouted Marathi, and I had to speak in Marathi plus Hindi for at least the next 2.5 hours. So communication is also important. I'm not saying that me speaking in their local language helped, but at least they understood that I am willing to talk their language. It is basically small steps to show that, okay, fine, you are not someone who's an officer of the court who comes in swanky cars, comes in a suit and just talks something in the air which they don't understand. So your communication has to be on a ground which passes on the message, which tells them, the only message which I passed on to them in that entire 2.5 hours is that I'm the most temporary guy over here. I am not the promoter. None of the money which this factory is going to earn will go back to the promoter or to any creditor. Everything will be plowed back for this factory itself. And that's a commitment which I had given to them. Not saying that that worked. Again, after 2 months, there was again a strike. So strikes will happen because at the end of the day, these are people. They may not look at your words, they will look at your actions, but slowly and steadily, we have started stabilizing the payments. Most of the payments have now come on stream. So they are also happy. The work is ongoing. There are issues as far as productivity, efficiency is concerned, because everyone understands you're an IRP, you cannot throw them out of the job. So they also understand and they also start reacting. But how you communicate, how you deal with them as an IRP becomes your first impression, and which is very important. Now, the second avatar in which you are there is the RP. So you may not be the RP, but you may still be the IRP till an RP comes over. So that does not mean that you take your job lightly. Remember, the creditors are watching. The same COC who has voted against you and voted in favor of another RP is watching you, how you behave in those 1 month, 1.5 months till that NCLT order comes. How are you going to hand over and all those stuff? Because in another case, they may take the decision of not replacing you only because looking at your conduct. They may not know you today, but they know you because of your conduct. So it's very important that handover from an IRP to RP happens very smoothly, very efficiently. As an RP, your job is to navigate the entire resolution process. More of your management skills, communication skills, negotiation skills, navigating skills are going to be handy over here. Once the process comes to a success, of course, the implementation is also another new headache, as I would call it nowadays, because there are a lot of delays that we've seen in implementation, interpretation of some portions, etc. So if your resolution plans are not drafted well, your implementation may go for a toss. Now comes the role of a liquidator. When you wear the hat of the liquidator, the mandate is very clear: sell, 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 sell. Bechna hai. That's the only mandate. The only thing that should come in your mind is, how am I going to sell? At what price? Who are the bidders? Engage with them. Understand what is the value of the asset according to them. Understand if you need to do a fresh valuation. Understand what are the key pointers in this asset, because the USP of the assets will have to be marketed by you. You also need to understand at what price point you need to hold the price and not put in, just keep on reducing the reserve price on a mechanical basis. As a bankruptcy trustee, I believe a few of the IPs have now also become bankruptcy trustee. Again, the idea is very akin to a liquidator, but I believe individual insolvencies would be much more complicated in terms of dealing with individuals, dealing with people. Corporate insolvencies, that's my understanding, I may be wrong, is quite simpler. So what are the key expectations in any of your role, be it an IRP, RP, liquidator, bankruptcy trustee? Is timely completion of the process, value preservation and maximization, fairness and transparency, and adherence to a legal framework. So these are some of the key expectations, not very high expectations which people have, but these are some of the key expectations which they are going to expect from you from from an insolvency professional. Adherence to legal framework is very important because we've seen cases now where you have included some PRA who was not there in the final list. Since he was not there in the final list, he could not have submitted a resolution plan, and his resolution plan has now been approved by the COC. And when the NCLT sees this, there is a problem. It has wasted at least 6 to 8 months of work which the COC and you yourself have put in. So adherence to legal framework is very important wherever and whenever you are in doubt. Always take help of legal professionals. Always reach out to the COC members individually, also on a personal basis. Take guidance, take some forward-looking guidance from them, because that would really help you. Otherwise, call for a COC, minutize the discussions, minutize whatever is the proceedings and whatever are the views of many of the members, and go forward. So expectations are quite a few when you are an insolvency professional, because the market looks at you as more of a messiah than any else. But of course, you will not have to take that role very literally. Your job is to adhere to the legal framework. At the same time, try to complete the process in time, maximize the value for the creditors, and have fairness and transparency as far as your entire process is concerned, including the process that you're running for inter se bidding or a Swiss auction process, or whatever challenge mechanism that you are running for maximization of the value of the company. So why management and leadership skills matter? Management and leadership skills definitely matter, because time is a constraint. Time is a constraint with too many activities scheduled at the same time. Now, too many things have to be done at the same time. I am fortunate to have quite a few cases, so I have something or the other on my table with too many to-do lists to do. So time is a constraint. So how do you effectively manage your time? How do you effectively take decisions? If you sit on decisions, then nothing is going to work. Most of your assignments are going to be at a standstill. So within the constraints of time, you will have to do too many activities. So time management is very important. That's why I said when people look at you as a leader, they will then start doing work, because they know that he is not going to get into the nitty-gritties of what am I doing. So the CFO, the CEO, the factory head, everyone knows that, okay, this guy has developed his trust on me. Whatever I tell him, he generally says yes, because that's what consensus is. You always have to listen to the expert, to the best man, rather than driving your own agenda. So within the time constraints, you have to do too many activities. And that's why I said delegation is very important. Delegate it within your team, delegate it to the company management. You have to delegate this to external experts like legal counsels. You cannot sit on a legal application and say, okay, fine, let's put this, not put this. As long as the crux of the application, the facts are there, it is supported by case laws, it is fine. I mean, you may not need to fine tune the document to 100%, but as long as it is 90-95% there, but 100% on facts, as I would say, facts have to be there. You should not miss out anything. So your time management and these skills will come into play on how effectively you manage. Uh, I actually do 2 to 3 COCs in a day sometimes, because you have now everything online. Prior to COVID, it was very difficult to do 2 COCs or 3 COCs in a day, because everyone used to come physically and it was not humanly possible for you. But since it is online, of course, you can do multiple meetings online, one after the other. You don't have to travel. So use technology, and that is something which is going to help you manage very effectively. I think those who are managing 2 assignments can manage 4 assignments because of technology. If you use technology a lot, if you delegate activities, if you have most online meetings, I believe most of your schedule in the day will be wiped out in no time. So everyone is unpaid, including delayed payments to professionals appointed for the process. So everyone who comes will have some grouse or the other. So how do you manage these complaints? As I would say, these are not complaints, but I would say these are grievances. How do you take care of these grievances? How do you explain them? Sometimes valuers call us, transaction auditors call us, legal counsels call us saying that we've not been paid. Now we've requested the committee of creditors to make payments, but they'll also take their own sweet time. I'm not saying that they would delay it knowingly, but there is a delay in the entire process. It's an administrative process for a bank to release payment, take approvals, etc., etc., etc. So everyone is unpaid and everyone has their own grievances and everyone is looking at you. You are the smiling Buddha for them. So your job is to cajole everyone, bring in consensus, bring in that sanctity, saying that, okay, fine, things will be fine, things will be smoothened out. Give me a couple of months. You will have to navigate that process, and your skills as an individual, as a professional will definitely be put to test. How do you speak? You just can't say मुझे नहीं मालूम, मुझे मत बोलो. Goods मुझे दिया था क्या? Did you give services to me? If you start speaking that language, a 15-minute meeting is going to happen in an hour. I'll give you a very interesting discussion which happened in one of my cases. We had imports and exports. So when you do exports, you always you appoint these clearing and forwarding agents, CNF agents. So one of the CNF agents was holding my bill of lading, and he was not releasing the material, saying this unless and until you pay me by money. So we sent him email saying that this is against a moratorium, section 74. You cannot violate moratorium. We will start offenses, penalties, everything. Nothing worked. So one day I get a call saying that he wants to meet. Okay, fine. So he came to the meeting. He sat in front of me, and that meeting lasted only for 45 seconds. He asked me only one question. Are you in a position to make the payment? Will you make the payment? Unless you make the payment, I will not release your BL. I said, I've told you an email. I've given it to you in writing. This is a pre-CIRP payment, which cannot be done. I will have to take legal recourse. He said, thank you very much. And he walked out. So this was a 45-second meeting. Not that I asked him to walk out, but he walked out. And after 8-10 days, he released the bill of lading. It's not that looking at my face, but probably he wanted an audience. Probably wanted to understand from the horse's mouth कि पैसा नहीं मिलेगा. So sometimes people want to meet you, and it's always important to give that time to those people so that you develop relationships with people, because when people meet you face to face, a lot of things get resolved. A communication on phone is very informal. A formal communication, a face-to-face communication, a lot of time helps to calm those nerves, to soothe those frayed nerves. So ability to withstand pulls and pressures from various stakeholders. You are on the radar every time. So as an IP, you're the focus of attention. You are on the radar, and anyone who has handled assignment will know that there are too many pulls and pressures from various stakeholders. The COC would want you to do something. The promoter may call you and say, okay, do something else. The customers may call you, the employees, the trade unions may call you, some creditors may call you saying that this is what has to be done, and you don't know what exactly to do. So you will have to keep on maintaining your own sanctity. So all these skills will be put to test when you are put to various pulls and pressures. Another example I will give you, I'm giving you examples because this is a forum of insolvency professionals, and it also helps relate to what the point that I'm saying. In another case, I had to go to Calcutta again to take over from an RP. So in this particular premises, this was Calcutta. We understand trade unions, various trade unions were there, and the RP's team told me that there was an incident over here. So we have imposed section 144. 144 is nothing that for 5 or more peoples cannot be present at that place. So that was 144, and they kept on renewing it every 3 months. So when we took over, I mean, we had to go to the factory. So they said that this is a very typical and a dangerous place. So better take police protection and go. So there were two factories to go. So we managed it in such a way that once you enter the factory, the word goes out. So first factory we went, no one understood that the RP had come. But at the second factory, there were at least 25 people who were waiting. So I told them, wait for some time. Let me do my factory visit first, since it's almost 3 o'clock and there is no lights over here. And I'll address you. So once I finished my factory visit, then I addressed that 25 people had almost become 55, 60. And the only thing which they wanted was to hear from you. They said the RP never came. He never spoke. He only spoke on the phone. We called him, but he never came here. I said, what is it that you want? There is nothing that I can do that you also understand. So let's wait for this process, assist in this process. There will be investors who would want to come and visit. Allow those visits, because it's in your interest. It's in our interest that this factory starts, the operations resume. The factory was shut for the last couple of years. The workers were hopeful of a solution, of getting some money, etc. So we only had to give them that confidence that I'm here to work for a resolution. And in my view, the resolution may end, say, in 6 months, 9 months, 12 months, whatever timeline, judicious timeline that you can give them. So you are the focus of attention. You are accountable to multiple stakeholders. So it's always important to communicate. Committee of creditors, an enigma at times. Sometimes you just don't know how to handle creditors. One day they were very sweet. The other day they have taken a complete 360 degrees turn. So managing committee of creditors, I mean, that's one of the most important skills. I think your entire skills are put to test when you manage the committee of creditors. I'm not focusing the committee of creditors from purely decision making, but I'm saying consensus building. They will take decisions because they have to go to their committee of creditors. But how do you build the consensus in the creditors, saying that this is the right path which has to be done? So as an RP, you will have to lay down all the possible paths which are available, be it the most easiest or the most toughest. You can say these are four options that we have. Option number one, option number two, option number three, option number four. Let's discuss each one by one. And according to me, maybe I'm suggesting option number two. But if someone has a point on option number four, so I am not seeing as the guy who's pushing option two, but I'm saying I'm looking at option two as a possible option. And in my view, so are the pros, so are the cons. So as an RP in a COC meeting, you should never be seeing pushing an agenda, because that is what I have learned they hate. So they want you to keep options, to tell them facts, and to assist them to make a decision. They want them to be making a decision. They want the COC to be seen to be making a decision. So they don't want a decision to be forced by an RP saying yehi hoga, iske alawa kuch nahi hoga. So doing that at COC sometimes backfire. Sometimes it works, saying that this is what it is, this is what will happen. Of course, it depends on the situation. It depends upon how your relation with the committee of creditors have been. So it's an enigma. I mean, the next COC meeting, I am there. It becomes very difficult for me to judge which way the COC will go. But for that, you have to do adequate preparation. They don't want to see an unprepared RP or an unprepared RP team. What we've understood from most of the COC members is saying that RP does not know. So if the RP does not know, does the RP has that humility to say that, okay, fine, I probably missed this. Thanks for pointing this out. Give me 2 days, I'll give you an answer. Sometimes RPs also get into a slanging match. So you should not get into a slanging match with the creditors. Of course, as an RP, you have power. As creditors, they will have power. And in a couple of my meetings also, there were voices raised. Of course, there was a point which I had to enforce, because that is what is the law. I said, this is the law and this is how it has to be enforced. But finally, other creditors would come in and they would try to resolve the issue. So never get into a slanging match with the creditors. Say that this is the point, this is what I'm telling, this is the law. If you have a different point, let's document this. A very recent case where the very similar case, which I said unfortunately went to liquidation, there were 4 plans which were presented finally. And one of the plan was termed as compliant. So as an RP, I gave an RP compliance certificate saying that this plan is compliant. Now the creditors did not want to vote and they wanted to take it to liquidation. So the lead member was hell-bent saying that, okay, this is a non-compliant plan. I don't want this plan to be put to vote. And he gave 3-4 points. Of course, every point was countered saying that, no, this does not mean this does not mean this, and this does not mean this. But at the end of the day, he was quite hell-bent saying that this has to go to liquidation. I don't want the plans to be put to vote. So then RP, what do you do? Do you forcibly put it up for voting? Say, no, this is my job. I will put it up for voting. That is what I said. I will have to put it up to voting. But yes, the COC will also have to deliberate. It's not that I just come and give an RP certificate and put it to vote. The deliberations on the resolution plan, the evaluation matrix, feasibility, conditionalities, the commercial offer, everything will have to be discussed, minutized, because that is the final meeting. Those minutes are going to the NCLT for approval of the resolution plan. So when the point came of he did not want to vote. So I asked for the other creditors. Some of them said, let's put it to vote because the RPA said that this is compliant. So I said, it's not that the RP is saying it is compliant. I'm also backed with the legal team, but at the same time, we may be wrong. We may be wrong. It may not be compliant. What the lead lender is saying may also be right. But as creditors individually, we all will have to take a decision. So finally, we took vote of each creditor. Many of them said the plan is non-compliant. We reached a consensus and we said, okay, fine. We will document it saying that the RP has said it is compliant. Legal counsel has said it is compliant. Now, creditors on the following points feel it is non-compliant and hence it should not be put to vote. And accordingly, the creditors have requested the RP to put an agenda for liquidation of the corporate debtor. So they would have voted against the plan, but they have voted in favor of the liquidation as we speak today. So once you go to NCLT, the NCLT may not then question you on why the plan was put to vote. Of course, the documentation in terms of whatever has transpired in the meeting has been told very transparently in the minutes. And finally, the creditors in their wisdom have voted for a liquidation instead. So that is something which is acceptable. Tomorrow, if the IBB also comes for a supervision, I think in terms of legally tying up, we have done. So that brings me to another point on judicial time. I have seen a lot of judicial members complaining that RPs file applications left, right, center, but it's not RPs who file, it is the legal advisors who advise the RPs to file these applications. So an RP's performance is also directly linked to the judicial time which is being spent by the adjudicating authority for supervision of the process. And judicial time is less. If they sometimes only give a couple of minutes for hearing a petition. Sometimes they may hear your petition for 2 hours. It entirely depends upon the discretion of the judge. It depends upon how heavy his board is on that particular day, which matters he may want to hear, which matters he feels is not, it has to be heard on the next date. So it is clearly a judge's discretion. And as IPs, we should minimize the number of applications that we are filing. So the quality of the application is very important so that if a judge has read the application, I mean, he's quite clear in terms of what exactly you are seeking. So our job is also to have some legal skills to reduce the judicial time which is spent by the adjudicating authority for supervision of the process. Managing people and conflicts, including hostile management. So I think I've covered quite enough that people skills is very important because you have to deal with hostile management, disgruntled employees and unpaid vendors. Navigating, engaging, delegating, understanding laws applicable to the corporate debtor and its regulatory regime. So if you are handling a company which has a mine, so reading the mining contract is also very important, and it may not be a part of your scope, but if there are issues relating to the mining, then obviously you will have to read the mining agreement, read at the Minings Act also. So you'll have to do all those things to upgrade your skills also, and also to understand the laws which are applicable to the corporate debtor. Finally, empathy. Empathy has to be there. It can't be sympathy saying, oh, you've invested in this company. That's purely wrong. There has to be empathy saying we understand the decision. Whenever it was made, probably was the right decision. But things could have gone wrong. So things have gone wrong today. So always have empathy towards creditors, but it should always be backed by strong decision-making ability. So leadership and management skills are very important for insolvency professionals, because beyond your legal acumen, beyond your financial acumen, what is more important is how do you manage the entire process for a successful outcome of the process. uh, Management and leadership skills do matter. Any questions? I'm not seeing any questions. I mean, let me open it up. If any of the participants have any questions, I can take it up. Anyone?
No questions, sir. The topic itself is very dry, sir. So nobody is interacting.
No, it's a very interesting topic, madam, because people have a lot of, I think even experience sharing is also fine, but fine. Right. So we'll go ahead. Yes, sir. You were saying something? Go ahead, Srinivas ji, Mr. Srinivas Mehta.
Good evening, sir.
Good evening.
In your deliberation, you said we have you have to give COC a lead role uh, in the meetings,
In negotiations and
in negotiations and all. In COC meetings, we have to make COC members to go little far ahead in the discussions. If you if we do that, they will sit on our heads sometimes.
No, which is fine. What
Already they are doing.
Mm-hmm.
Most of the IPs are complaining COCs are not discharging their duties properly.
Right, sir.
They want to take control over IPs.
That happens, invariably happens. I agree to your point.
Please, how to handle both the things.
Right. That's what I said. I mean, the committee of creditors, it's an enigma. I mean, it's very difficult to handle. And I'm saying after having so many COCs over the last 7 years, I'm not sure in the next COC whether the lenders are going to shout at me. So that's always a challenge. So what I've said is you will always have to empower the COC to take decisions. If for a particular aspect you give only two options and they come up with two options, it may also always happen like that. So they say, oh, this is also possible, this is also possible, this is also possible. So always engage them into a discussion and say, okay, fine, if these are the possibilities, let us discuss the pros and cons and let's come to a conclusion. Ultimately, it is the COC who has to decide. As a RP, I should not be seen forcing a decision. That is the last thing which any COC would want, saying, oh, this RP is telling me to take a decision. Why should I take it? That means he has some interest. So you should be as neutral as possible, and it is the COC who should be seen as taking the decision. Of course, I am spoon feeding them to take the decision which is the right decision, and that probably is the correct option according to me. But we also have to realize that we are dealing with people, and the committee of creditors, there will be various peoples, and these are bankers having 20 years experience, 30 years experience, senior bankers. So they have also seen the world. So we also will have to respect their position. So mutual empathy and respect is what will have to be exhibited by an RP in a COC. So if you give respect, probably you will get respect. If you start questioning them, it becomes a little bit of an issue. You should always ask, sir, okay, so what is the solution? So tell me, sir, what is the solution? What is the option? And that's how you build consensus. Secondly, I said at the time of negotiation. So as an RP, your job is not to negotiate with the PRA. You should always, before you call the PRA, ask the COC who is going to negotiate. Say, why don't you negotiate? Why doesn't SBI negotiate? Who's the lead member? Why doesn't Axis Bank negotiate? Because you're the lead bank or the top two lenders. Why don't you all negotiate? So always give them that role. if you just call the PRA and start negotiating and they say, okay, COC, you have something to say, I mean, then these are only small matters I'm saying. I mean, this is my learning over the last 7 years, having handled various laws. So I've been very fortunate that most of the COCs that I handle have 30 members, 25 members, 28 members. There are COCs which are 4 or 5 members also, but handling a large COC is a very different matter. So in one of the last cases, which I took over as RP from another IRP, the IRP and the COC, there was a complete breakdown in communication. So when I took over, of course, they chose me, they appointed me because unless the COC appoints you, you don't become the RP. And from that meeting onwards, it was smooth till now. We've done almost 15 meetings from that day till today, and it's quite smooth. So a lot of the other creditors who are not there in many of the COCs saying that, okay, we used to think that COCs is for fighting. But at least you've shown me that there is consensus building also. So it all depends, sir. I mean, it's your experience. Every COC you'll become wiser and wiser and wiser. And I think that's what we as humans are. Never put down a COC member saying that you don't know anything, you read the law and come. That is never. You should always. I'll tell you, I mean, if you are in a assignment for more than 2 years, some of the COC members will change. They don't read the minutes of the meeting. You can't tell them, "Aap padh ke aao." So take those 5 minutes, explain them. Sometimes they also say, "I'm really sorry, I have not read the minutes. Can you please explain?" Some of the COC members come 15 minutes late, 20 minutes late, half an hour late and say, "Mr. Menezes, can you please in 5 minutes recapitulate whatever you said, whatever has happened?" So you'll have to go that extra mile. You just can't say, no, I'm not going to do that. So these are small nuances, sir, which I think each of us as professionals would have learned along the way.
Thank you, sir, for sharing your practical experience.
And that's precisely the reason I'm here. And that's why I'm requesting everyone, I think, let's open this up so that
I
we have
heard
these issues.
the delays, sir. I ha I heard from our fellow IPs, most of the delays are occurring due to COCs are sending their proxies, not original persons who are having power to present in the COC meeting. That's why a lot of delays are happening. So how to overcome those things, sir?
You can't overcome that. Please understand, if you enter into a SAM branch, a stressed asset branch, the DGM who's in charge, who's the decision-making guy, handles at least 80 to 90 cases. Below him, the AGM has at least 20-25 cases. And now IBBISN have a COC every month. In some of our cases, we have at least 4 COCs in a month. It depends on at what stage the process is. So you cannot every time expect that a decision maker comes. But sometimes when you feel a decision maker has to come, so you should reach out and say, sir, this is very important. I would request your personal presence. Or you could tell the person who's sitting in the COC saying that these are the matters that are going to get discussed today. Why don't you speak to your boss and come prepared? So some of these things will help. That's what I'm saying. Only opening a forum and saying, okay, fine, I have come here now. I hope everyone who's come here is empowered. No one is empowered. Even an AGM will have to take an approval from a DGM. A DGM will have to take an approval from a GM. A GM also sits, and these are public sector banks. They will have to create those records. Someone will have to propose, someone will have to accept. So it's a process for them also. So they take 3 days, 4 days, 5 days, 6 days. And I think that's a part of life. I mean, that's how I take it. Howsoever much we push becomes very difficult. But in very critical meetings, you request 3, 4 banks, their higher ups to come. And I think they oblige, sir. That's not an issue.
Sir, another thing I wanted
Yes, sir.
small this small explanation from the small what I call this thing. When they are changing the IRP, how he can behave coolly with the COC, sir, in case of replacements and all those things.
Coolly means what stake have you got in this assignment? Have you invested? The answer is no. You have been just appointed by the court. You are there till the creditors enjoy your performance or your role. See, as consultants, even when we go for a job, They take interview of 10 people. Not everyone is accepted for that job. Only one is accepted, 9 are rejected. So rejection does not mean that, okay, they have rejected me. Probably they thought that I was not fit for the role. You can always ask for guidance. See, even as RPs, today I go and we go for these bidding process whenever they ask for quotes from RPs. Not every case comes to me. I mean, I should not be unhappy with it, right? It is their call, it is their decision. Take it with a smile, move on. I mean, that's the only way to deal with it.
Okay. Okay.
Because
Thank you.
we have no stake in the process. We have to
Sir,
understand
even
that.
I thought of asking the same similar question.
Yes,
The COC, as you said, they don't have enough time to read the minutes of meetings, and they will also not read the instruction whatever we give in the notice itself. Every time we will call them and inform them, but still they will come unprepared only. This is this is the way it happens, and the change of RP, I mean IRP to RP, and even the change of liquidator. So they are taking the call just like that, sir, without even giving some valid reason. So that I don't know how to handle this. Uh,
see, I'll tell you, I mean,
just because the RPs are, I mean, some IPs are in their panel, they are not continuing the IRP as RP. That is the only reason most of the financial creditors are saying you are not in our panel, so we cannot continue. And moreover, their bargaining is, it's like for PG matters or not, it's like they are bargaining in thousands. There will be a criteria to charge the minimum fees for by the IP, but they are breaching that. There is a circular also from IBBI that RP fees, professional fees, should not be less than 1 lakh. Minimum fee itself is 1 lakh, and depends upon the size of the assignment, it should increase. But there are many financial creditors, they are bargaining and negotiating. Whoever is quoting the lesser, the least value, they're choosing only those IPs. So in that that whether it is encourageable way, or how to overcome this kind of difficulty.
so I'll answer your last question first. As far as fees is concerned, I mean, it is always the prerogative of the COC. I mean, you can always say no as an RP, saying that, okay, I can't do this in this fees. I mean, and as professionals, I think a lot of time
We may not get assignment at all.
which is absolutely fine. I mean, which is absolutely fine. If you think that it is not
But
worth
we will for sustaining in the field, something is better than nothing. We will
so
apply
that's a
that
call,
concept
ma'am.
and we will accept no, at
Yeah,
least for gaining experience.
but that's right. So I'll tell you, I mean, as an RP, I don't pick up personal guarantee cases. I mean, I just don't, not because of the fees, but because I believe there is nothing much to do there. So as a professionals, it's always better to keep those boundaries. If you get into like, I mean, there was a time when RPs were quoting 20,000, 25,000, 30,000. I mean, I used to tell a line to most of the COC members, please go ahead and appoint him, sir. आपको भगवान मिल गया है. We get drivers at this rate. So not to be sounding very arrogant, but the point is that, I mean, if someone is quoting, the COC will also have to see that who is quoting and for what. That's where I think IBBI came up with that minimum fee guideline. Of course, they said this is minimum, and that minimum does not apply to IPEs who are IPs, but for individuals it apply. And I've seen that some of the individuals are still going below that, and I don't know how and why. But you will have to maintain your own space, madam. See, fortunately, I have been one of the earliest IPs. So I'm 41 on the list. Today there are 4,500. So I have been that way fortunate to be at a time when there were too many cases and too less of a competition. But then the creditors have also trusted us looking at the way we've worked. Now, whenever replacement comes, I would always advise fellow professionals, don't get anything minutized. I mean, there is nothing to be aggrieved of if someone is replacing you as an RP. IRP, RP, or as a liquidator. I tell in all my cases that I am here as long as I enjoy your confidence. I don't want to be in an assignment where The creditors don't trust me. I mean, what am I here for? The objective of the code is resolution, maximization of the value of the assets. And if the creditors don't trust me for it, I mean, why am I here for? So there is a certain level
Actually,
of
in my assignment, when I was ready to file a dissolution application, they retained me. As the moment I decided to file Section 19 and 2 application, they said it is time to change the liquidator. So they appointed another liquidator in my place. So even the present liquidator who is appointed, who replaced me, he is actually filing the same thing whatever I intended to file, because that is assignment where we cannot avoid certain things. That is a
this is
flaw. We
right.
cannot leave some flaw.
Right, right. So I think every professional is different, and that is where I think the first heading of the slide is also why management and leadership skills matter, because the ability to say no, that is also a very strong character, right? If you can't do it and if they are not allowing to do it, it's always better to step down. I mean, we will do our job regardless of what the COC members will think. And I think that's how it is. If you're getting replaced, so be it. I mean, that's the way I look at it. Of course, you can go and make your case, but if they have decided, then you can't help it. Now, as far as panel is concerned, I think this is a very common feature in most of the public sector undertakings, not only banks, but also in other public sector undertaking. They generally form a panel and they give work without in the panel, because imagine having a bank with the branches across the country. Right. So they need a centralized team who will scrutinize IPs based on their criteria. And from that panel, someone gets appointed. Now, there are pros and cons of this, but I think let's look at it as a reality in life. Of course, I am on the panel of most of the banks, but in some of the banks, even after 7 years, I'm not on their panel. So that's fine. I mean, you can't help it. But yes, I mean, that's a practice which most of
Thank you, sir.
have. Yeah, most of them have. Right.
Thanks, sir.
Thank you. Thank you, sir. So I think now we get into, I think Madam said that this was more of a dry topic. I think the dry things start now. Strategic thinking and decision making. So the ability to quickly assess financial operation and legal aspects. I mean, this is a skill which is needed, I mean, for any IP. Most of us are professionals who come from compliance backgrounds, company law background, CA background, tax backgrounds. Some of them have worked in corporates, and they also have, some of them worked in consultants. Many of the IPs today and most of them who are getting work are ex-bankers. So everyone has their own skill sets. Some of the lawyers have also become IPs. So these are some of the skills which are needed. And if you like, I'll tell you, I mean, when I was a chartered accountant, when I started my IBC practice, and after a couple of years, I realized that, and I had interest in law. So I did my law a long time. So during COVID, I passed my law also. So when you start reading something, because a part of my job was also reading the law, interpreting the law, reading jurisprudence. Otherwise, you have a law firm who's going to tell me, okay, this is how it is to be interpreted. You have a COC member telling me this is how it is to be interpreted. So I also quickly upskilled myself and I said, why read law? Just take a law degree. So that also helps you. You'll need skills. So when you have to build your own business, when you have to build your own self, then in that case, you have to see what are the shortfalls that you have. So studying law does not mean that you will understand anything and everything, but at least basics of law you will know. Even as chartered accountants or company secretaries or even as cost accountants, we are exposed to reading laws, be it the Companies Act, the SEBI law, or the Income Tax Act, or the GST. So some basic understanding of law is already there. So our job is now here to apply the law. So application is to apply the law, make those decisions under certain circumstances or circumstances which are uncertain. How do you plan the entire process? The entire CIRP is a project. You will have to divide that into various buckets, create SOPs internally within your team, track those SOPs. Otherwise, CIRPs today, if you're handling 4 or 5 assignments at a time, becomes very difficult to manage. Strategic planning for turnaround or liquidation, as I've said in one of the examples which I gave, The IRP ran a process for the company as a whole. When I came in, I started a cluster-based approach and even a Regulation 29 approach. Why did Regulation 29 strike me? Because I had done this earlier in 2019. So you learn from your own past. And in 2019, when we were faced with a situation saying, "Okay, this can we sell, can we not sell?" We went through the regulations and we found out Regulation 29, and it did fit our bill that time also. I think that was one of the first Regulation 29 things which was done. So as IPs, we will have to quickly think in a manner so that the entire problem is bifurcated into small, simpler questions. Rather than looking at the whole problem, we can bucket it in a manner which we are able to digest, which we are able to understand, and which we are able to decide. If you are not able to decide, please take professional help, because not everything under the sun is what you can do yourself. Prioritizing conflicting stakeholders' interest. Now, everyone understands, and I think I've heard from a couple of them also, and I think a lot of IPs have also told me that managing COC, conflicting stakeholders' interest, someone is secured, someone is unsecured, there are unsecured creditors. So everyone will have their own fight. So you will have to probably speak to each one of them separately before they come to a COC meeting, try to understand where a consensus can be built, and there at all you will have to then play around, make those worksheets and say that, okay, this is option 1, this is option 2, this is option 3, but I think option 2 might work because of X, Y, Z, ABCD reasons. These are the pros, these are the cons. And then enable the COC members to take a decision. See, again, I'm saying you, when they see themselves making a decision, they will stick with that decision. So we had a COC of 26 members. I think around May 2024, we had to decide about distribution. And in this particular COC, 55% of the lenders were secured and 45% of the lenders were unsecured. So one without the other, the plan was never going to get approved. It will never get a 66% unless the unsecured creditors are played. So then we started, okay, fine, 90% to secured creditors, 95% to secured creditors, 5% to unsecured creditors. And then we built on saying, okay, fine, you can do with 80-20, you can do a 50-50, you can do as per the ratio of the voting share in the COC, you can do based on the security interest. Then a lot of people are getting zeros, but you can do something in between of this also. So if you're able to build a consensus, fine. Generally, what I advise in most of the COCs is that you don't discuss such matters in the COC. You call for a JLM, because a lot of time lenders understand the JLM concept. So they call for a JLM, and within the JLM, where maximum of the members are there, then they decide. Or we also call for another separate meeting after the JLM with all the other COC members just to do brainstorming, not to get into a decision, but all decisions will be done in the COC meeting. If you have a large COC of say 25, 26 members, when you get into negotiation with 10 PRAs, 12 PRAs, 5 PRAs, it becomes very difficult to do it in a COC. So you do a subcommittee approach, a subcommittee, and you call PRAs at a specific time, invite all the other members, whosoever can come, but these 5 members will have to come. So that's the way you strategically plan for conflict, for stakeholders' interest. You'll have to invite their interest, invoke their interest in the entire resolution process. And once they get interested, it is not that it's a decision, ha ya na bolo. You have to involve them in decision making. So these are some of the skill sets which I believe most, I'm not saying that I'm very successful in doing this, but I attempt this. Even if the COC is of 2 members, 3 members, I try and attempt this, that getting consensus, telling them the entire facts. And just to answer one of the questions, saying that the COC members come unprepared, you should be very happy as an IP. किसी को कुछ पता ही नहीं है, right? So if they come unprepared, you may spend 15 or 20 minutes more. But if they are fully prepared, then there may be gaps in your knowledge and your preparation also. So it works both ways. An unprepared COC is sometimes good and sometimes very bad. So as an IP, you will have to then plan for a workaround. If you know that they will have to come prepared, tell them in advance, speak to them in advance, go and personally meet. So all this is relationship building also, because that is where they understand you. They will understand that your interest is in resolution. Your interest is aligned to the creditor's resolution, not their particular interest, but the interest of the resolution. See, these are also professionals who are working in banks. They are also, they have seen uh, a lot of promoters, a lot of professionals, legals, IPs, etc. And they also understand how people work. So it's very important to build a personal rapport with the COC members, and keeping the interest of the corporate debtor in terms of resolution, maximization of value, resolution in a time-bound manner at the heart of all the activities that you do. Communication and negotiation. So transparent and persuasive communication with stakeholders. So when I gave you that example with the COC, put all the facts, 100% of the facts should be there on the table. It has to be a persuasive communication, but you don't have to force it. As I've again said, facilitating COC meetings is an art. I mean, we may spend an entire day sharing experiences, but the next COC may still be an enigma. You may be able to crack it. You may not. You may crack yourself. So it all depends. I mean, so I think before you go to a COC, I mean, at least I do is prepare. I prepare. I read everything. I understand what the agenda is. What are the documents to be placed before the COC for taking certain decisions. So we prepare ourselves. The team also prepares. Sometimes we prepare the COC members. So facilitating COC is very important, because an ill-informed COC may take wrong decisions, and hence guiding them is also very important. A lot of time, I have a lot of bankers calling me for advice, saying RP is doing X, RP is doing Y. So in some of your cases, they would take advice from us or very similar IPs whom probably they trust or have a good working relationship with. So as an IP, your communication, your understanding, your negotiation skills is very important. You have to negotiate with creditors, debtors, regulatory authorities, employees. Like in one of our cases, the mine was shut by the Ministry of Coal. So we had multiple meetings with the authorities, explaining them that why this is important, why it is important for the CIRP, for the corporate debtor to survive. 1,200 families are dependent. So at least after 3, 4 meetings, nothing happened, but we went to NCLT, we went to NCLAT. And finally, they said, if the NCLAT decision comes in your favor, Mr. Menezes, we will not go to the Supreme Court. And they stuck to that. So you will have to be persuasive. Keep on going, keep on meeting, keep on speaking. I mean, your job is to plead, beg, because at the end of the day, the operations of the company is very important. You just can't say, let the CEO go and meet the mining authorities. I have no interest. Plant chalega, chalega, nahi chalega, nahi chalega. That is not what you're supposed to even say. Conflict resolution and crisis management. So this is also another important aspect. I think what we'll do is currently we'll take a short break. I think, can we take a break of 15 minutes if you all don't mind? 10, 12 minutes. Madam Anjali? Madam,
Okay,
can
sir.
you?
Okay,
Yeah.
sir.
Yeah, let's take a break of 10 minutes. I think we'll resume at 4:25. Thank you.
Thank you.
स्लाइड चेंज हो रही है
नहीं
मीटिंग लोग तो नहीं
I am not able to hear.
So can we start now? 4:30 we'll start. So next is conflict resolution and crisis management. I hope I'm audible to everyone. So essentially, I mean, the situation that we are in is nothing but conflict and crisis management. So as an IP, you will need to manage and navigate and mediate just to avoid any litigation, just to avoid any further conflict, just to avoid any further crisis. So you should not be seen as the person on account of whom that conflict has arisen. In one of the case where I replaced one of the liquidators, I mean, there was a very tumultuous relationship between the SCC and the liquidator, which finally led to the removal of the liquidator. But I think as RPs, our job is to manage the conflict, manage crisis, not be a reason for the crisis or for conflict. That's why I said if at all they want to replace you, it's always better to go out with a smile as long as they don't write anything which is negative against you. So one of the essential skills which is required to manage disputes, etc., is mediation. So as an IP, you will have to understand what exactly the subject is. I mean, and some of these subjects would be really difficult subjects for you to deal. There may be a contract where at least 10, 12, not 10, 12, I'm saying 5 to 6 years of work has happened. Now, suppose there is an arbitration and an arbitration entails a contract which was entered into 2014 and the work got terminated in 2021, 2022. Now, for the entire 6, 7 years as an IP, you will need to understand what exactly is this issue. Because if you are in a discussion with the principal, which is the main contractor, or the person who has given the principal who has given the job, which are essentially government departments, whether it is NHAI, it is MORTH, it is any state road development corporation. So when you discuss with them, they will expect that you know everything and anything out of this. So very important is to get into a mediation mode and to tell people that yes, you are not a puppet, because a lot of time people think that RPs are puppets and the erstwhile management is making them right or not right certain things, or the creditors are acting tough and they are getting it done through the RP. So RP's job is basically to resolve conflict, manage disputes between creditors, promoters. A lot of time, the creditors feel that uh, this guy is talking the promoter's language. So what the promoter was talking, so promoter went out and a new promoter has come in. That's how banks describe RPs in some of the occasions, saying that I am handling a new promoter and this promoter is a educated promoter who's got an official license. So your job is to not talk the language what a promoter wants, and at the same time the promoters would also say that okay, fine, a fresh banker has come with a fresh license, of course, who's talking the creditor's language. So your job is somewhere to balance it and be as neutral as possible, be as independent as possible. How you're seen, how you're perceived is very important in the entire analysis of your role, because a lot of people are watching you, how you are handling situations, how you are discussing, how you are negotiating. So your job is to preserve the business value at the end of the day and not get into a fighting situation. I've told you there is also a lot of media scrutiny, especially when you are working in big assignments. I have seen even in my own cases where the COC happens, and even before the COC concludes, the news is out in the open. A lot of people ask you if this is true. Can you comment? Can you comment? So that becomes a problem. So media scrutiny, especially in large accounts, is very uh, is very much there and very difficult to avoid their sources, because they have all the information much more than what you as an IP has, because someone has given that information. The COC thinks the RP has given the information. RP thinks that one of the creditors have leaked, or the directors who have come to the COC meetings have leaked. But at the end of the day, I mean, your job is to manage all this under the work stress that you are currently having. Ethical leadership and integrity. So obviously, as high standards of independence is what is required. In a lot of cases, you will be dealing with related party transactions where the parent and the subsidiary is having a relationship, of course, a working relationship, but all these related party transactions will need approval from the committee of creditors. So you have to be very objective in seeing that these are arm's length transactions and these are not transactions which will further come under the scrutiny of enforcement agencies or the IBVI. Upholding the code of conduct under IBC is paramount, and that's what everyone expects you to do. Reporting fraudulent transactions with impartiality, not try to hide something under the garb of this may or may not be in terms of gray area. So how you manage a PUFE application, because when you sit in the RP sit, everyone understands that this is the guy who's going to file an application terming me as a fraudster, and that's what promoters have a lot of resistance with, that how you handle their PFE applications. In a lot of our cases, we've seen RPs, promoters, creditors getting into a slanging match saying that, oh, you have doomed this company. I generally advise most of my fellow professionals that it's very important to respect the promoter for whatever he has done. Building a factory or a business, borrowing hundreds of crores, leave aside 10 crore, even 10 crore is a big deal. Borrowing 10 crores or doing a turnover of 50, 100 crores is a very big thing, and we should respect the promoter for what he has done. But at the same time, I am saying that we will also have to be cognizant of our uh, duties under the code. So filing of avoidance applications, preferential undervalued, extortionate credit and fraudulent transactions. And at the same time, we should also give the promoters or the ex-management a chance to reply, understand their perspective, understand the rationale in which that particular decision was taken. Finally, you will have to make your own opinion and file an application, but it may always be better to give them multiple chances to put their stand. So whenever you go in court, at least it doesn't happen that it's a one-sided application without taking a feedback or management responses, as we commonly call. Team management and delegation. I think if you do this, most of your job is done. I think you will be relaxed as an RP if you are able to have skills of team management and delegation. As I've said, delegation always comes with a lot of trust, a lot of accountability, because if you delegate your authority to someone, you will also have to make him accountable and understand that whatever actions he or she takes would obviously fly back to you. So team management, always invest in your own team, invest in their skills regularly, keep them abreast of the legal issues, discuss issues which you have seen in other assignments. So having your own team is a very important aspect in the entire management process of a CIRP or a liquidation process. You can always take support of outside support teams if this is your first or the second or third case. But I would always encourage IPs to invest in their own teams, having a team who undertakes IBC processes, because this is a specialized knowledge and you just can't have a person doing everything. So this is a specialized skill set that is required, a specialized field to assist an IP in his overall role. So your team as well as the team of the corporate debtor is also very important. So you have to provide overall leadership and clarity to the CD team. The CD team, most of all, requires clarity of thought. So they know as an IP, if you don't go back on your word and what you've told once. So I always tell the team, please tell me all the facts. So based on the facts, I will take a decision. If you give two more facts after 2, 3 days, based on the document that we see, the decision is going to be different. So don't say that I said something and did something else. I will do what I say as long as you give me a complete picture along with the document. So in many of the CD management who work with me understand and know my style of working. They know what he needs and what he hates and what he likes or what he dislikes. Similarly, the COC also judges you as a person. So your job as a leader and imbibing those leadership traits, delegating those responsibilities, trusting the team, having a feedback mechanism regularly helps very important in managing the entire CIRP process. So overall leadership and clarity to the CD team is an absolutely must. At the same time, you're also leading a team of legal, financial, and operational advisors. Most of these are experts in their own field, so you can't teach a lawyer law, is what they commonly say. But at the end of the day, if the lawyer or the legal firm knows that, okay, this guy also understands laws, he's also well read. In some of the cases, what we do is we send relevant case laws to the legal team saying that why don't you look at this and see how it applies or does not apply to our particular situation. So you will get respect only when you are well researched, when you are well read, when you understand and have your entire facts ready. Because what a legal advisory firm or a financial due diligence firm is going to do, it is going to work on the documents that you have given. What is a valuation exercise? Valuation exercise is a perception exercise that this is the perceived value of this asset. And that perception will come based on the associated facts around that asset, the legal documents, the title documents, any encumbrances, any issues relating to the title, occupation, possession, returns, what are the lease rentals that a particular asset is enjoying? Does it have a lock-in period? We've seen some tenancy agreements having a lock-in period of 20, 21 years, 8 years, 10 years, 12 years. So the valuation exercise will be as good as the information which is provided. Always discuss with the valuers, not on the valuation, but what is the methodology that they are following, what is the right way to value the particular asset. Many of the chartered accountants, or I think many of the fellow professionals are also SFA valuers or are land and building valuers. So you all also understand how a particular asset has to be valued. Unless you know your asset, no one else is going to know your asset as well as you know. So be it a legal team, financial due diligence team, operational advisors, valuers, transaction auditors, it's very important for them to be led to a particular direction and say that this is the thought process, this is what has been discussed with the management team, this is what has been discussed with the creditors of the company, this is the line which they are thinking they want to take, and we may have to align with that particular line as long as it aligns with the objectives of the code. And delegating tasks while maintaining accountability. Everyone runs a team, so everyone understands a delegation. You can't do everything by your own self. Everything, if it comes back to your table, is a very big issue. Then you will not have personal bandwidth. Because professional life and personal life to a large extent for an IP gets mixed. I have seen cases where I am on holiday with family, but at the same time, I'm attending to calls, having COC meetings. So a lot of mix-up happens between personal and professional time. So delegating tasks, having a schedule mapped for yourself and for various activities is always very important. So we generally have a weekly task to do as far as our teams is concerned, just to understand how many COCs, SCCs are to be done, what tasks are pending. So having those Monday meetings, weekly meetings does help even with the company management and with your own teams. Operational and financial oversight. So financial analysis, cash flow monitoring, I think less said the better. Most of you all are experts in your own rights. Business continuity planning and operational control. So some of the skills are required basically, which these are core skills as I call it. These are not the softer skills. Leadership, management are most of softer skills, but these are core skills. Unless you are good at your work, unless you can read the balance sheet properly, unless you can understand the notes to accounts in an audited financials, unless you know what are the company law procedures, none of the people are going to respect you, be your advisors or the COC. So for you to be respected, for you to be seen as someone who can navigate and steer the entire process, people will have to know that you carry in-depth knowledge. So you will have to be well-read, well-researched, know your subject very well. If the COC starts teaching you IBC law, then I think that is the end of your IBC career, as I put it to a lot of fellow colleagues, that never let anyone dominate you. Of course, there is always a collective and collaborative decision making, but if people start dominating, that means you don't know your job. Of course, certain traits are there where people would want to dominate, and sometimes you should be submissive also enough to tell them, okay, this aspect is also there. If you're saying it right, I think it's fine, because at the end of the day, you're the creditor, and what you decide is the right course for this company, because the creditors are going to shape the future as far as the CIRP is concerned or the liquidation is concerned. As an RP, your job is to facilitate. So if you are thorough with your job, if you understand finance, if you understand operations, if you understand numbers, what is the cost to complete, what is the revenue that is going to come, what are the issues around this project, that helps you manage everything in the CRP well. This helps you ensuring an asset security, cost control. Periodic reports will also have to be given to stakeholders, adjudicating authorities. So having a tight control on the operations and financials is very essential to to perform your role as an insolvency professional. Regulatory and legal acumen. I think everyone over here knows that IBC is what you should know. If you don't know the act, then there is a problem. If you've not read the amendments and if not thought about how it affects your existing cases, I think that's a red flag. Understanding a basic understanding of the Companies Act, SEBI regulations, the land laws, tenancy laws, labor laws. See, all this you will come to know only when you get into an assignment. When you get into an assignment and we are faced with specific mining laws, specific land tenancy laws, SEBI regulations, you have to get into it to understand this. I mean, you just can't expect someone to come and brief you and say, okay, this is fine. I will take a legal opinion and move ahead. Wherever it is complex, complicated, take a legal opinion. But the legal opinion always has to be with your own understanding about your subject, your own research about the subject, because at the end of the day, you're not the promoter, you are a professional yourself. Insolvency professional is a professional of professionals, and that is the correct word. You don't behave like a promoter, you behave like a professional. So when you take a professional opinion from someone else, you also undertake certain due diligence to understand that this professional opinion is correct or incorrect. Adherence to timelines and documentation requirements is also very important. I think a lot of you who would be handling infrastructure companies will agree with me, EPC companies will agree with me that there is a huge litigation portfolio as far as infrastructure companies or EPC companies are concerned. Most of these contracts with the governments eventually end up in litigation, liquidated damages, claims, counterclaims, arbitrations, conciliation, you name the word, it is there. So I have been fortunate in handling at least three infrastructure companies, and you learn a lot in infrastructure companies because there are no assets. You have to get money out of thin air, saving bank guarantees, getting arbitration claims, fighting those arbitration cases, disputed claims, because none of the asset in the infrastructure company would be clean and clear, because the contract itself runs into hundreds of pages. So very important to have knowledge about the contract act, and especially in infrastructure companies, your legal skills, your negotiation skills will be honed a lot, because there's a huge litigation portfolio. I had one company which almost had almost 60, 70 cases, and slowly and steadily we brought those cases, managed it into buckets, allocated it to specialized teams. Not everything can go to one legal firm, because someone may be good in contract, other may be good in arbitration, someone may only be specialist in IBC matters but may not understand the contract. So hiring the right people, so some amount of regulatory and legal acumen, and these skills are very important for an insolvency professional to go about his duties in a very smooth and expeditious manner. Emotional intelligence, I think in today's day, today's time, I think this is more required. We have artificial intelligence, which has to a large extent reduced our workload. This presentation is also a mix of artificial intelligence and my own application of knowledge. But then, yes, emotional intelligence is something which we need empathy, patience, and tact in dealing with stress promoters. A lot of these promoters, please, we have to also understand that what is a promoter, what is his identity. His identity was his business. He has invested his entire life, sweat, blood in this business. Now whatever has gone wrong, whether it is siphoning, whether it is genuine stress, whether it is genuine stress plus siphoning, I mean, this is something which has already happened before you came in. So you have to very tactfully deal, because promoters come with huge egos, they come with a lot of connections, and they always have dealt with yes man, because be it their CEO, their CFO, their HR head, their factory head, everyone has learned to say yes, because that's what a promoter is all about. He is the risk taker. He is the one who mobilizes men, material, money, resources all together. So handling promoters and handling bankers are two different skills. Many of you would think that handling promoters is very easy, but handling a banker is difficult. Both are equally important, because if you have to navigate your skill, because the only guy who is going to delay your entire resolution process is a disgruntled promoter. He will do a lot of schemes behind your back. He may speak so nicely with you, and a lot of PRAs would be backed by the promoters. A lot of litigants would be backed by the promoters. So your job is also to see through and deal very tactfully so that it does not impact your performance as an insolvency professional. It does not lead to delays in the entire CRP process. Self-awareness, regulation, emotional regulation, these are some of the words. I will not get into these details, but everyone understands that patience is one of the key words as far as an IBC is concerned, because NCLT teaches you patience. COC does not teach you patience, but NCLT teaches you patience. A decision which could have been done, you think, in 15 days has taken 15 months because you've decided to go in court. You decided to go in court because of two reasons. One, you did not anticipate, negotiate, communicate, enter into a dialogue. Second, you did and you failed, right? If you did and you failed, then it is fine. But if you've not done any talking, any communication, any notices, any letters to be written, any engagement, and just went ahead with the litigation, in most of the cases, I think this litigation is futile. To give you an example, intercreditor dispute. Generally, banks fight amongst themselves and there is an intercreditor dispute. I think this is one of the disputes which can be tackled very easily. A promoter creating unnecessary disputes can also be tackled by dealing with the promoter, discussing with him. He comes to the COC meetings. You tell him that everything is transparent. If you have to say something, say in the COC meeting. आपके पेट में दर्द है, आके बोल दो. Doesn't matter. Whether right or wrong doesn't matter. You have your view because the law allows you, being a director, to be a part of the COC meeting. But if a promoter is not a director, we generally call him only if the COC calls him. He has no automatic entry. So the promoter should also know that since he is a director, he's sitting there. Had he not been a director, he wouldn't have sat in the COC. So telling him the law at the same time respecting him is also very important. A lot of you may or may not agree, but every IP will develop his own style of dealing with people. And I think in most of my cases, I have good relations with promoters, good relations with banks, good relations with PRAs, and that helps to tackle any issues by communicating, by understanding what the pain point is and trying to get a mid ground. So trying to get a mid ground, negotiating, communicating is always better. But at the same time, you'll have to also have to maintain your ground, maintain your boundaries as far as professional duties and professionalism is concerned. Technology and data management, we all are equipped with virtual data rooms, e-auctions, various compliance tools, which IBBI has now. We'll have to fill up those monthly reports, quarterly reports, periodic filings, disclosures with the IPA. So technology and data management skills in this virtual world, especially during COVID and after COVID, has become very important. It has eased our life. I actually only do virtual COC meetings. If the COC tells me to physical meetings, I'm the last person to do it because I enjoy doing virtual meetings because you can, in a physical meeting, what happens is a lot of times people come in late. So the meeting starts at least 45 minutes late. That's what I've seen in Mumbai. I'm not aware about outside Mumbai, but I've seen at least 30 to 45 minutes. People used to come late whenever we used to have physical meetings. And a lot of lenders nowadays prefer virtual meetings. And I've seen lenders, whenever you go to the bank, they sit in 3 COC meetings at the same time. So many of you of whom you complained that, okay, they don't come equipped, they don't come prepared. I have seen people attending 3 meetings at one point of time. So everyone understands span of attention, multitasking. It's virtually impossible in this digital world for them also to manage so many COCs. Continuous learning and adaptability, since everyone chose to attend this seminar, obviously it does mean that you want to also learn from other professionals, exchange ideas, exchange views. Uh, in in IBC, nothing is black and white. I mean, you will have to tailor made it to your own requirements of your own corporate debtor, your own issues. created man-made artificial issues or whatever legal issues are there, whatever regulatory landscape is there. So it's a continuous learning and adaptability. And as an IP, I think we should always be ready to learn and accept our mistakes. If at all there are mistakes, it is always better to say sorry and say, okay, fine, I did not see this coming. It's a mistake from my side. Probably this would help me evolve as a better professional. I mean, it's always better to accept a mistake if at all there is a mistake. So it does, I mean, if you try hiding behind mistakes, it becomes it's a see-through pattern. And creditors, promoters, stakeholders, even IBBI for that matter, if you tell them, yes, this was a mistake, a lot of time they call you and say, oh, this has happened. And you say, no, this is a mistake from our end. We'll ensure this doesn't happen or this doesn't get repeated. So even the regulators do listen to you, because at the end of the day, you are human and you are in the process of continuous learning. An amendment may have come with the regulations and you may have missed it. It is always possible. So it's always better to read the amendments well in time, understand how it affects your particular assignment, and then incorporate those changes. Applying new Supreme Court rulings, I told you, Technology Development Board, earlier it was Arcelor New Metal, Innoventive, those who are from the 2017, 2018, 2019 era may know it. The newer IPs may know Technology Board, Rainbow, I think almost everyone knows. And Bhushan is a very recent case. So applying these Supreme Court rulings also becomes very important. Everyone will have their own view. You may have to develop your view and decide how to take forward your particular assignment, taking all creditors together, IBBI guidelines, regulatory amendments, etc. Any questions you all have? Role of chartered accountant. So the other topic which was given to me apart from management and leadership skills for IPs is a role of chartered accountants under IBC. Not only chartered accountants, company secretaries, cost accountants, advocates. I think everyone has a very pivotal role. Everyone can do the same thing what CAs are also are capable of doing. But yes, I mean, everyone has their own specialized fields. A company secretary is much well versed and an expert as far as corporate laws, SEBI laws, capital markets are concerned. A chartered accountant is more equipped as far as accounting, auditing, taxation is concerned. A lot of us are into specialized services of transaction audit, financial due diligence, valuation, and this is open to all professionals. But since my topic says the role of chartered accountants, I'm only going to talk about CAs. So a lot of CAs are also IPs today. I think almost 50% of the IPs are CAs. So as chartered accountants, even I'm also CA, we bring in our unique financial expertise, our understanding of tax laws, our understanding of regulatory mechanisms, our understanding of operations, because we've done articleship, done audits. So we have that flair as far as numbers are concerned, compliances are concerned. I've been an ex-banker, so I come from a banking background. It becomes very easy for me, touchwood, to negotiate with the committee of creditors because I know what is their pain point. I directly ask them, tell me what's your pain point, and I'll give you an answer. Let us directly come to the point rather than beating around the bush. So a lot of bankers may have a lot of internal compliance issues, internal issues of how does he put it across to his higher management. So sometimes being a banker also helps me to explain them in my own way on how this needs to be done and how he needs to handle this internally. So as chartered accountant, as bankers, we have our own unique skills. So advisory role for IP. So CAs can always come in advisory role, come in support services, do forensic accounting. Generally, we call it as transaction auditing as far as IBC is concerned, identifying all those transactions, diversion of funds. Financial due diligence, assessing the financial health of the corporate debtor. CAs are in the forefront of this domain. Valuation, performing valuations. So CAs can also take on role as valuers, registered valuers under the code. Auditing, of course, is a compliance requirement, but sometimes you may also need to do a CIRP cost audit or a particular transaction or a contract audit just to understand that this contract, whatever numbers you are giving in an arbitration or in a legal dispute are correct or not. So you can do a contract project audit also. So most of the CAs, since their background is auditing, can do scrutinizing of books, project auditing, etc. Taxation, of course, is one another aspect where chartered accountants have their forte. So managing the tax implications during an insolvency process, haircuts. I mean, none of us, including me, are able to tell any COC members that what would be the tax implications. Will the PRA be in a position to take advantage of the tax losses which are there? So that will depend on very complex structures which the PRA will have to do, looking into the taxation laws and hiring experts. So in one of the cases, I was asked, no, what is the value of the tax losses? And I said, I don't know, because tax losses would also mean that he has to do profits. And how he does profits, I don't know. So one is the write-offs in the books, which will going to come the write back as far as haircut is concerned. All those will get subsumed with the carried forward tax losses, which is there. That's what I understand. But different people may have different ways of managing tax. If you're in a very similar business, you can merge it and probably get a greater tax benefits. It all depends on what is the structuring which is done by the particular PRA. Of course, to add a value to a finance to a tax loss is a very difficult assessment, is what we generally tell the COCs. Formulation of resolution plans. Now, resolution plan, as we all understand, is a legal document, but more than a legal document, it is also a commercial document. So CAs can help on the commercial aspect. The lawyers can help on the legal aspect, and fine tuning the legal and commercial aspect is what is the requirement of a resolution plan. It is not a commercial document. It is a commercial come legal document. So chartered accountants can help in financial structuring and advising the SRAs on resolution plan. They can also present these resolution plans. They could take up advisory roles for the RP process, advisory for finding investors, evaluating the various resolution plans, evaluation matrix, giving marks as far as evaluation matrix are concerned, conducting feasibility and viability studies. So all this can be done by chartered accountants. They can also be done by company secretaries and other professionals too. One role, I think, which many of us were looking forward to when the entire pre-packaged insolvency resolution process came in, because a lot of it has to be done in advance. So a lot of IPs were looking at giving advisory services, not becoming an IP for a pre-pack PIRP, but generally looking at a PIRP from the perspective of telling them that how the entire PRP, because the entire PRP will have to be done in advance, and then the pre-pack is brought to the court, and within a period of 90 days the entire process has to be closed. So there was a large opportunity which most of the professionals did foresee in the entire pre-package, but unfortunately is not taken up. We can also assist claimants, creditors, to file claims as operational creditors, financial creditors, assist them in understanding the insolvency process. If there are minutes, sometimes you can also become an authorized representative. Home buyers need understanding about the minutes, etc. Sometimes the AR does not have too much time, because if there are 800, 900 home buyers, it becomes very challenging for the AR to reach out to everyone. So you can also perform these roles as chartered accountants, as other professional, or as IPs, doing advisory roles for creditors and debtors. So CAs and IPs working together, there are a lot of synergies, and 1 plus 1 is equal to 11. Very complementary skill sets for an IP, which is process management, legal oversight, combined with CAs, financial expertise, and an audit rigor. So you can complement your skills as an IP with that of a chartered accountant. It's always advisable. So generally when we hire chartered accountants, but if you don't have a team or don't want to invest in a team, so you all can also look at CA firms who provide support services. So uh, always a CA firm will help you when you probably are short on financial expertise and may not have the skills for doing a transaction audit, because as an IP, you may have to first understand the transaction yourself, look at the books of accounts, and then come to a conclusion. So these are complementary skills which a chartered accountant can or any other professional can bring in. enhanced due diligence. So chartered accounts would provide in-depth financial analysis, strengthening the IP's findings. So you have a sounding board uh, with you always saying that, okay, this is something which looks fine and this is look okay. Chartered accountants bring insights into businesses, into resolution plans. So you can take the assistance of a CA for feasibility, viability, building robust resolution plans. So the point is that there are too many synergies between an insolvency professional and a CA working together. Ultimately, when two professionals work together, there has to be collaborative approach to overcome complexities, and joint efforts will always bring in the trust integrity. In most of the COC meetings, the way we handle COCs is if I'm not able to handle a question, I put it forward to my legal counsel to answer. Not all questions have to be answered by the IP himself, because once you deflect that question to a legal person, the legal person will answer, and you have some time over there, some breathing time just to think about a solution. So one man speaking, like I am speaking continuously for 3 hours, so my mind is blocked. So when you run a COC meeting, when you have a support services team, when you have process advisors, when you have lawyers, it is always better to show that you are working as a team. So collaborative approach is very important. Everyone would love to hear their own voice, including IPs, lawyers, etc., because we all love to talk. But at the same time, when you go into any assignment, you work as a team. So a collaborative approach will overcome a lot of challenges and solutions. So the role of a chartered accountant providing support services, specialized knowledge is very important in an IBC process. And I think as IPs, we can look forward to working with professionals to conclude the process in an expeditious and time-bound manner. Any questions that we have? Developing skills is always a continuous journey. So formal education, certification, practical experience. Some of us want to work with some seasoned IPs and professionals. So a lot of IPs I've seen, they work with other IPs on some of the assignments, attend seminars, attend these physical meetings of networking, learn industry best practices, stay updated with the amendments. A lot of time IBB also calls you for roundtable. So it's always better to hear from other IPs on what are their views on a particular subject. But nothing beats practical experience, and of course networking will help you build relations with a lot of peers, legal experts. So when you meet people out on an informal platform for networking on a social platform, it becomes very easy to connect because you don't have professional boundaries at that point of time. Even meeting with regulators, I remember in the first 6 months that we took up the role as an IP, one of the judicial members in Mumbai did have an interaction with a select team of 8 to 10 RPs just to understand what is it that we are facing challenge. There were two benches at that time at Mumbai. Now, of course, there are 7 benches with 6 benches performing. So one of the judges, the judicial and technical members did call us and try to understand that where IPs need support. So it was a very interactive session with the judicial members. So all this really helps in developing your skills. So as an IP, you're a multifaceted person. You are into a profession where you are looked upon, and every successful resolution is applauded by your peers, by creditors, by stakeholders, by the PRAs. A lot of it is also captured in the news. So that also brings and adds on to your credibility as a professional. So I think with this, I come to an end to my presentation. I had also thought that this would be much of an interactive session, but unfortunately, there weren't many questions around. So if there are any questions, I still have another 15-20 minutes of my time left. I am open to questions. And in case anyone wants to speak with me on a personal basis, my mobile number and email ID is there on the screen. So over to you, members. Any questions that you have for me? No questions? Anything, I mean, anything on IBC is fine. Fine. So I think over to the moderator.
Shall we conclude, sir?
Yeah, we can conclude now. There are no questions, as I
Okay.
understand.
Thank you very much, sir, for sharing your knowledge and giving so much of learning. Sir, you are requested to please share the PPT of the session so that I can share with the participants.
I think there is one hand which is raised. Srinivas ji, you want to ask something?
Okay, okay, sir, you can take up the question.
Sir, you said suppose some 13 PRA applications have come. Shall RP has to give prepare a report of 13 fellows and give it to the NCLT, sir, or only successful resolution application approved by the COC he has to submit to the NCLT, sir?
So it's only documents relating to the successful resolution applicant who has been approved by the COC. That's the only thing that you have to say. You'll always say in the compliance certificate, etc. number of PRS that had come. It may be there as a part of your application, but I think the details to be shared is only with relation to the PRA who was successful.
Thank you, sir.
Sure.
Sir, RP has to minutize whatever talks he had with all the PRAs, sir?
Yes, sir. In a COC meeting, whatever has transpired has to be documented. To what extent you will document is up to you, but it's always better to document maybe in a summarized manner. Otherwise, if you have 13, 14 PRAs, you may run into 100 pages of minutes, which is not advisable. So you can summarize the key discussions which were there.
Okay. Thank you, sir.
Fine, ma'am. So I think there are no further questions. I will take leave. Thank you, everyone.
Thank you very much, sir.
Thank you.
Thank you.